Good morning, everyone. I'm calling this hearing to order. For the record, my name is Kendra Lara, District 6 City Councilor, and I'm the chair of the Boston City Council's Committee on Housing and Community Development. I'm joined this morning by my colleagues, Council President Ed Flynn from District 2, Councilor Liz Braden from District 9, and I have a letter of absence from City Councilor at Large Aaron Murphy that reads, Dear Chair Lara, I am writing to inform you of my absence during today's City Council hearing on docket number 0412 regarding a hearing to create a Renter's Bill of Rights for the City of Boston. A representative from my staff will be listening in and following up with me. I look forward to reviewing the footage and following up as need be. I sincerely regret that I could not attend this hearing this afternoon, and as I made prior commitments that I must keep. This hearing is being recorded, and it is being live streamed at boston.gov/city-council-TV and broadcast on Xfinity Channel 8, RCN Channel 82, and FiOS Channel 964. Today's hearing is on docket number 0412, an order for a hearing to create a Renter's Bill of Rights for the City of Boston. Written comments may be sent to the committee email at ccc.housing@boston.gov and will be made a part of the record and available to all councilors. We will be taking public testimony at the end of today's hearing, and if you're here with us in the chamber, please sign up at the sheet near the chamber entrance if you're interested in testifying virtually. Please email Juan Lopez at juan.lopez@boston.gov for the link. For all testimony, please state your name and neighborhood or affiliation and try to keep your comments to 2 minutes. Joining us today from the Mayor's Administration, we have Bob Terrell, the Executive Director of the Office of Fair Housing and Equity. We have Danielle Johnson, the Deputy Director of the Office of Housing Stability, and Joel Wool, the Chief of Staff from the Boston Housing Authority. Welcome, and thank you so much for being here with us today. Also joining us today from our community panel, we have Mark Martinez, Housing Staff Attorney at the Massachusetts Law Reform Institute, Alex Ponte Capellan, a board member at City Life Vida Urbana, and also my former Chief of Staff, and Mary Statos, who is a member and organizer with the Greater Boston Tenants Union. Before I turn the floor over to our panel, I would like to acknowledge my council colleagues for any opening remarks in order of arrival. President Flynn, you have the floor.
Thank you, Madam Chair, and looking forward to hearing from the panelists that are doing important work in the city. These city officials are professional and hardworking and provide tremendous services to the residents. I'm also looking forward to hearing the testimony from the law students from Boston College as well. I got here early before the start of the hearing, and I had an opportunity to listen and talk to some of the students, but impressed in their professionalism and hardworking dedication to supporting tenants. And I did a little bit of research last night on this topic, and I found that most tenants, the students could tell us this, but most tenants that go into housing court, unfortunately, go into housing court without any legal representation. And the landlord, when the landlord goes into housing court, they always go in with legal representation. That makes the difference. But want to acknowledge these students, law students. They play a critical role in supporting tenants, but it's important that we also provide tenants with the opportunity and availability of a competent lawyer going into court. I think that's also a critical part of the discussion as well. But I want to say thank you to you, Councilor Lara, for the important work you are doing in protecting tenants across the city. Thank you.
Thank you, President Flynn. Councilor Braden, you have the floor.
Thank you, Madam Chair, and thank you to all of the panels here this morning and all the folks who are attending to give public testimony, etc. I think a Tenants' Bill of Rights is a critically important tool for us to establish and use as a framework for ensuring that all of our residents in the City of Boston have access to safe and secure and hygienic housing, and that they have supports to help them address deficits in that housing, and support when it comes to going to the Housing Court to address the issues that they may be having with their landlord. So I look forward to the conversation this morning. It's a really, really very important conversation that we have, and I'm very thankful to our Madam Chair, Councillor Lara, for her leadership on this. Thank you.
Thank you, Councillor Braden, and thank you all for being here. This is really an exciting time, not just for the Boston City Council, but for the City of Boston, as we are, for the first time in a very long time, being led by leaders who are really committed to not only ensuring that there's enough affordable housing in the City of Boston, but that the affordable housing is being built for the people who live here, and it's safe and accessible, and that we are not only fighting against displacement and gentrification, but protecting our tenants and ensuring that they can stay in our home. I want to start off today by taking a moment to honor Mel King. As a lot of the folks here know, we have lost an incredible, incredible giant to the City of Boston, who was really pivotal and a leader, and to a lot of people, the creator of the housing justice movement in the city of Boston. Mel King was one of my mentors and somebody who I learned so much from, along with so many of the other young organizers and youth organizers in the City of Boston who come from my generation. My good friend Alex Ponte Capellan, who will be sitting on the panel later, and Armani White, who is one of the co-founders of the organization Reclaim Roxbury, they wrote the epilogue to the reprint of Chains of Change by Mel King, called The Future Link of the Chains of Change, and really talked about how Mel King influenced us as housing justice organizers and what it meant for our future, and how we would ultimately look to him and all of the organizers and the housing justice organizers that came before us for guidance. And so here we are now, elected officials, leaders in the housing justice movement, and we all have very big shoes to fill. So my hope today is that this hearing is anchored in the legacy of Mel King, and that the conversation that we have here today is as consequential as it needs to be, and really sets the tone for the work to come ahead. It is our turn now, so let's do him proud. I am going to turn the floor over to our panel now. Do you have an order, at least the administration, in which you want to speak?
I'll go last.
I'll go.
Okay, so we're going to start with Director Johnson. Director Johnson, you have the floor.
Thank you, Councilor Lara, and Thank you, Councilor Lara, and the Housing Committee for bringing this hearing to the floor. As a former legal aid attorney, this topic is very important to me. My name is Danielle. I am the Deputy Director for the Office of Housing Stability, and I'd like to start by talking about OHS's mission, because I do think that's a guiding principle for us when we are talking about tenants and their Bill of Rights and their rights in general. So OHS's mission is to maintain and sustain stable, safe, and affordable housing. Our office is very front-facing, so whether it is a family who is coming to our office because a family member is the target of a rival gang, or it is a single individual who has fallen behind on rent and is unable to sustain their tenancy going forward with rental payments, or a family whose landlord is threatening to evict them without any type of due process. These are the type of phone calls that we get on a daily basis, upwards of 90 calls a day regarding these types of crises. And while crisis is a big part of our role, we also try to encourage eviction prevention. So we do a lot of upstream eviction prevention work, so collaborating with legal aid to host a weekly legal clinic. We work with Greater Boston Legal Services, where constituents can virtually ask a lawyer a question, or they can ask one of our mediators a question, or a member of our staff a question regarding their legal rights. We also have a housing search workshop that we run on a bi-weekly basis, where we provide tenants with what they should know prior to moving in. So what the state sanitary code looks like, what the fees you should be paying when you move into a unit, what are legal fees, what Chapter 93A even means, so apprising tenants of their rights as it relates to moving into a unit. And then we also work with the Eastern Housing Court, which has jurisdiction over the City of Boston and the housing court cases. So working with them collaboratively, we have a table that we provide twice a week, Tuesdays and Thursdays, where we sit in the clerk's office and provide constituents assistance, whether that's rental assistance or providing them with other resources if the tenancy is no longer sustainable, trying to figure out a way outside of the court process where they don't have an eviction record on their file. So utilizing that type of assistance with the housing court. And then we also have our Housing Stability Notification Act, which was enacted in 2020 due to the pandemic. That is another way where we ensure that landlords are notifying the city of when a notice to quit is filed, so that notice to quit comes to our office and we're able to do upstream work by notifying tenants, hey, you just received a notice. Are you aware that you have to be at a first tier event? Are you aware that you have a motion hearing coming up? So also working with the courts collaboratively with that and with the landlords throughout the city. However, even with these robust measures, we still receive calls from tenants who have questions about fees. Landlords are very creative in the type of fees that they charge tenants. So a lot of our conversation with tenants is, do you know about Chapter 93A? Do you know whether or not your unit is actually up to code, and making sure that tenants have the agency and understanding to be able to have conversations with their landlord to say, my window is broken and it needs to be fixed, or having that conversation where I need a proper accounting of my security deposit. So making sure that tenants are aware of just their basic rights. And given the power dynamics, as Councillor Flynn had mentioned, when you do go to housing court, where there are 93% of landlords who are represented and only 10% of tenants who are represented, given that power dynamic in court, but also outside of court, the Bill of Rights is more important than ever in ensuring that tenants feel the agency and autonomy to be able to assert their rights. And then further, tomorrow, unless there is legislation that changes, Chapter 257 of the eviction moratorium ends, which is another measure that prevented a lot of evictions in the city from happening. And given the slow uptick of evictions that are happening, which we've seen about a 72% increase since around this time last year, and a 90% increase of executions that have been issued, using Biden's principles as it relates to renters as an initiative, our office would be very excited to participate in. So I just wanted to end with that, and I really do thank you, Councilor, and the committee for bringing this to the floor. We look forward to working with you in this initiative. Thank you.
Thank you so much, Director Johnson. Director Terrell, you have the floor.
I'm next.
Do you want to go last?
I'll go last.
Okay, beautiful. Mr. Wu, you have the floor.
Okay. Good morning, Chair Lara, members of the committee. Thank you for the invitation to testify today on a renter Bill of Rights. The Boston Housing Authority, as you know, we are a large property owner, but one with a public mission to serve extremely low-income tenants, seniors, persons with disabilities, and many other constituencies. We really work tirelessly at that agency, and I see it every day in what my colleagues are doing to ensure that people have a place to call home and that they can stay there. And I think that as we sort through this, I think it's really helpful to have the national principles outlined. What I'd like to do, just for a few minutes now, is talk about what we do and how it lines up with some of those principles that the Biden administration put out, and I think the city, through offices like Housing Stability and others, really readily embrace. So what I see and what the federal government has what the White House has put out there: safe, quality, accessible, affordable housing, clear and fair leases, education, enforcement, enhancement of rights, right to organize, eviction prevention, diversion, and relief. So the BHA has long-standing engagement with each of these principles. And in part, there is the component of it that's law and regulation around our requirement to provide safe, habitable, affordable housing. And there are also the efforts we put in to make that happen. We continue to pursue resources to improve the capital status and address the capital backlog on our properties. And we're grateful for the city, which under this administration and under this council has given an unparalleled partnership to bringing buildings to where the level that, that tenants really deserve. And we will continue that modernization effort so that people have quality, affordable housing, even if they're at low, extremely low, or no income. We don't come about this to the council as much, but we operate several voucher programs, the largest of which is the federal Section 8 voucher, and we administer thousands of Section 8 vouchers in eastern Massachusetts. In that, we are not simply making payments, but we also run an inspections operation. So we have inspectors traveling not only throughout Boston, but through communities in eastern Massachusetts to make sure units are up to code. And that's not simply done at the outset, but we review units periodically, and we respond to tenant complaints as well. And when there are issues that come up after a tenant is already living there, we get into a process with them and the landlord to try to address those. So we have the work that we do on our own housing communities, and then we have the work that we do in the private market through the voucher programs as well. In terms of leases, our lease, there's pretty extensive things that HUD and DHCD do require, and we, I think, embrace those. We also do everything in our power to make sure that the lease is available, accessible to all of Boston's diverse constituencies who might be living in our housing. So on a basic level, right, you can go on our website and see it in English, Spanish, and Chinese. We can provide it in other languages for other populations. We house people who speak Arabic, Somali, Albanian, Russian, we have many communities there. So both we implement the numerous requirements passed down by the federal and state regulators, but also do everything we can to make that accessible to people however they arrive at our door. In terms of the kind of education of rights and the right to organize components, these are, in public housing, we have really strong requirements and protections, and our leases, and the law also explicitly outlines that tenants' right to organize is constitutionally protected. But if you pull up our actual lease, it reiterates that that is a commitment that we recognize that we make that. We don't simply just kind of acknowledge the law, though, and we enhance, I think, and implement some of these principles through communication with residents, through training, and through ongoing engagement with the local tenant organizations, as well as any other tenants that are engaging on our properties. Especially this week, and to your point and your beautiful acknowledgement, Chair Lara, I just wanted to note that the leadership program that public housing tenants in Massachusetts, that many of them go through, is one that's run by the Mel King Institute. It's been an established program for years, and it helps us build and maintain successful and thriving tenant organizations and have tenant leaders continue to be empowered and continue to be to provide feedback and to also share knowledge throughout their communities. And again, while the tenant organizations are not the only body for tenant action or activism, that is a critical one, and we're grateful to Mel King and his legacy. One small aspect of which, of the many things that he did, was creating that, or leaving that legacy of tenant organizing and education that has been formally institutionalized now, and we benefit from tremendously. In terms of eviction prevention, diversion, relief, we really work on our own accord. We work to stabilize tenancies. The basic way that we do that is if someone is behind on rent, right, we do try to work with them. It's repayment agreements before other things, but we also work with people to find rental assistance. And we have a really close partnership with the Office of Housing Stability. I think I'm particularly proud, during the pandemic, we set up a rental relief program that functions internally to the BHA that is city supported. And the reason we've done that is because when someone applies for rental relief, they have to provide a huge amount of documentation, and the landlord does as well. And because we have so many rules that we're already following, so much information about who lives in our properties, we're able to pull a lot of that information instantly. While there's still a large volume, And while there's still quite a process to get from, the application to the endpoint, it, I think, will accelerate because it has tremendously accelerated the work we do collectively to support public housing tenants and staying in their homes, particularly those who suffered among other ways financially during the pandemic. Because we can just gather a lot of the information that people who are in distress may struggle to compile, stacks and stacks of paperwork and financial records. So we have tried to facilitate that, and I'm grateful again to the mayor and council, as well as to my colleagues at Housing Stability and other city offices who have created avenues for tenants to receive support. Outside of that, we do refer tenants to RAFT and other programs, and we continue to work through other measures. There is a basic dynamic, even if we're a public interest entity, that we are a landlord and our tenants are tenants. And we understand that sometimes what's critical in these interventions is not just resources, but it's also trust. And it can be valuable to have third-party entities engaging with tenants in that capacity. So we work through other partnerships like the Tenancy Preservation Program. We work with entities like Homestart. We work with people that the Office of Housing Stability has hired as vendors that may serve specific communities or sub-communities in Boston, right? Maybe it's a specific language group or a neighborhood or set of residents that they're better at working with. And our position has always been that even if it's a tenant where BHA has come to the point, for whatever reason, that we're saying this, you no longer belong in this property, we always prefer people to be represented by counsel, both because it should be a right, it should be guaranteed as a right, and because it is mutually beneficial to tenants and landlords when that is the case. We have better results for people, and it's something that we hope that we will really see throughout, the state and private market and elsewhere where the push for access to counsel is so strong. So thank you, and I'm always happy to talk more about the BHA, and we are in a constant process of trying to improve anything we do.
Thank you, Mr. Wu. Director Terrell, you now have the floor.
Thank you very much, and good morning, Madam Chair and members of the committee. This issue of a renter's Bill of Rights is something that really strikes a nerve in the Boston Fair Housing Commission, because every day we're out there working to protect the rights of our protected classes from housing discrimination of all forms. So we really look forward to working with the committee well beyond this hearing to see to it that a Bill of Rights is put in place. Just a couple of comments by way of context before I get to some specific recommendations I have for the Bill of Rights. What are rights? And why do we need a Bill of Rights? Because some folks are going to criticize this attempt by challenging as to what we mean by rights. Our own Bill of Rights in the U.S. Constitution might be a very good place to start, because the Bill of Rights was in fact a political compromise. It was a compromise that was imposed on the makers of the Constitution to guarantee that individuals, or at least some individuals, would not be overrun by the authority of the state. And they made that a condition upon which the Constitution was ratified. In the housing market, we have a similar problem. And a Bill of Rights would bring about a balance between the individual and the operations of the housing market. One of the concerns I have, and I'll talk a little bit more about this later when we get to the issue of leases, which my colleague from the BHA just raised. In the private market, people are coerced into signing leases that are not advantageous to them. You are presented with a fait accompli, a document that's already written, and if you don't sign it, you don't get to rent the apartment. This is a practice that is well known. And as you know, anyone who signs a contract, which is what a lease is, does so, if they do so under conditions of coercion, that contract should be null and void. But all too often, people succumb to that pressure because they need a place to live. So one of the things we should definitely put into a tenant's Bill of Rights is the right of a tenant to negotiate every aspect of that contract. And if that contract, if they cannot come to an agreement, then perhaps it should be submitted to some form of mediation or arbitration. Now, there are those in the real estate profession who will object, but I would remind them that anytime you start to study real estate, particularly real estate law, in the very first chapter of the book, it talks about property rights, and it describes those property rights as a bundle of rights that you receive upon taking ownership of a piece of property. I would argue that tenants also have a bundle of rights, because when they sign that lease, they have the right of use and occupancy, which provides them with some legal leverage over how their housing is going to be treated and maintained. Another important aspect of a Bill of Rights, I think Joel alluded to it briefly, is the right to organize. Again, all too often people don't because they fear intimidation and retaliation. The Bill of Rights should make it very clear, as we do in our Fair Housing Act, that if you file a fair housing complaint and anyone takes any kind of abusive action towards you, that is a second claim against the respondent. And there are very strict rules and serious penalties for that kind of retaliation, which goes on way too often in the city of Boston. So we need to really strengthen the anti-retaliation portion of a Bill of Rights. I also think, and this has been something that the council has debated back and forth numerous times, what do we mean by a just eviction? We're going to have to revisit that, because we know some of the evictions that are taking place in the city of Boston are being carried out because folks are engaging in not, quote, legitimate business practices when they raise their rents. They're doubling and tripling rents, cleaning out buildings, and forcing people out. That is not my definition of a just eviction. And I think the council needs to take very strong measures to make such behavior illegal, and within a tenant's Bill of Rights, give all tenants a cause of action in the courts. We may have to go by way of home rule petition at the state level to achieve that, but that protection needs to be put in place. I'll stop there so we can get into a further conversation, but those are some of my recommendations. Thank you.
Thank you so much, Director Terrell. At this moment, I'd like to acknowledge that we've also been joined by City Councilor at Large, Julia Mejia. Councilor Mejia, you have the floor for any opening remarks.
Thank you, Chair, and thank you to the panel. I'm excited to be here. Just uplift some numbers, just for the record. 24% of Boston area renters are renter households were severely cost burdened, meaning that they spent at least half of their household income on housing.
The number of affluent resident rental households in Boston bounced 182% between 2007 and 2010. And while the number of homeowners by households pulling in at least 150,000 increased by 83%. Affluent households are still unable to own and instead have to rent. This amplifies inequities as it drives up the cost of rent, with poor people unable to afford hiked up rents. The Attorney General's office received 918 landlord-tenant complaints in 2002. 918. With an additional 171 pleas for help through the AG's eviction help request form. Many of the complaints concerned unsafe and unsanitary conditions in rental units, rent hikes, and evictions. I'm going to stop with numbers. I'm just going to flow real quick. Because, my office on a daily basis gets calls from people who are either undocumented, who are afraid of reporting the type of conditions that they're living in because they want to make sure that they maintain their homes. And sometimes people are living in mold, rat-infested, just conditions that are just a shame. I'm in the chamber trying to find my words right here. But I think that when we're thinking about renters and Bill of Rights, I really do appreciate this whole idea of the right to negotiate a lease, because it should be a relationship that is on level ground. It shouldn't be the landlord being the king and then the people who are trying to stay in their homes to do whatever they can to maintain it, right? So I think that leveraging that power and giving renters an opportunity to stake their claim and giving them the tools that they need to be able to go one by one, tit for tit, if you will, levels the playing field. And I think that this is an opportunity for us as a city to not only support our most vulnerable communities who oftentimes go with very little recourse to be able to have something that is formal. When in 2021 and during the height of COVID, our office worked with civic associations across the city, and one thing that bubbled up to the top is that there is no consistent way in how renters are the way they treat renters in Alston and Brighton is very different than the way they treat them in Roxbury and Mattapan, and that there's nothing that is consistent. So having something that is formal throughout the entire city of Boston, a legal document that we can hold ourselves accountable to, gives renters the rights to really believe that they are being taken care of by the city as well. So I look forward to learning what that's going to look like and supporting my lead sponsors in helping to do just that. Thank you.
Thank you so much, Councilor Mejia. At this moment, I would like to turn the floor over to my colleagues in order of arrival for questions to our first panel. President Flynn has left us. Councilor Braden, you have the floor.
Thank you, and thank you for your presentation. I'm just curious, Dr. Terrell, about you say that the idea of negotiating every aspect of the lease, the contract that we're making. I think very often smaller landlords who are have a second apartment to rent or whatever, I think they do have that back and forward conversation with their tenants often. But I wonder how what you see the particular challenges of implementing that at a larger scale. I think it's a very good idea, but I know you anticipate a lot of pushback from the industry, so what are your thoughts on operationalizing that?
I think the biggest hurdle in implementing that idea is that some landlords, a lot of landlords, will have recourse to legal representation. And we need to make sure that tenants in that negotiation also have access to legal representation, so they're not intimidated by the process. I think we have to insist on that, because the very legal definition of a contract is that you have two parties of sound mind who are in a position to negotiate, without coercion, and the contract could be verbal, but better if it's reduced to writing. And we have provisions in that if the contract is in any way breached or there's a disagreement over its interpretation, that there be some source for mediation or arbitration. I think those are very important safeguards. Mechanically, it may be difficult to ensure that everyone has legal counsel, but that should be the goal. All too often, and I've seen this more so in the last decade or so, a lot of folks are going into court pro se, without an attorney. I'm going to date myself, which I don't often do. But when I first started doing this work, judges were very adverse to people coming into their court pro se. They would turn them right around and say, go find yourself a lawyer. Too many people are going into court without representation, and it's not working out well. The judge will oftentimes say, well, can't you folks go in the side room and negotiate and settle this? And they're at a tremendous disadvantage. So somehow we have to figure a way to rectify that. Because if we don't, we're going to see more people victimized by the very conditions that Councilor Mejia just alluded to.
Thank you. Again, I'm just wondering about the logistics, because I represent Alston Brighton, and I think 75% of the rentals turn over on the 1st of September. That's a huge volume. And a lot of the renters, it's as Councillor Mejia already referred to, every part of our city is different. We have a particular subset of renters in Alston Brighton. A lot of them are young people coming to college and they've never rented an apartment in their lives. We spend a lot of time working on calls to try and rectify really substandard situations and rat-infested places and all sorts of incredible housing conditions that shouldn't even be allowed, shouldn't even happen. But again, trying to get back to the logistics of implementing this individual negotiation of the lease in a context like Alston Brighton, where there's just such a huge volume of young people coming in who are very naive and no experience in this necessarily. How we would work with that, because I think when we talk about a tenant's bill of rights, we need to have something that will work across all scenarios in our city. So it's just a thought, just a question I have.
I think those of us in this fight have had the same question for quite a while, which is why I'm glad we're having this hearing, because I think it's time for us to have some sort of roundtable discussion and figure out exactly how to do that. Most of the major firms in the city have a provision where their attorneys have to contribute so many hours of pro bono representation. That would be a good place to start. That's not a complete solution, but at least we would get some level of representation through the volunteer hours that they have to put forth. That might be one place to start.
Yeah, and then so many of our leases are sort of boilerplate language. It's a template that comes out from the Massachusetts Realtors Association or whatever, it's sort of a standard. One size doesn't fit all, of course, but I think that's what the sort of landscape that we're working in right now.
Right. And we shouldn't be signing those without representation.
Okay, thank you, Madam Chair.
Thank you, Councillor Breeding. At this moment, I'd like to acknowledge that we've been joined by Councillor at Large Ruth Zilujan. Councillor Zilujan, you have the floor for any opening remarks.
Opening remarks? Okay.
Yes.
Well, good morning, everyone. Glad to be with all of you to be discussing how we can further protect our renters in the city of Boston. We know from the data that that evictions are increasing in the city of Boston, and so there's such a power imbalance between tenants and landlords. And so any way that we can intervene in that relationship is incredibly important. I was just Sunday night at the home of a constituent in Hyde Park who received a notice to quit and believed that meant that they had to leave. And so often people don't know and aren't aware of their rights. As someone who started my legal career in housing court as a housing attorney with the Harvard Legal Aid Bureau, it is oftentimes not even enough to have, there aren't enough lawyers in the courtroom to really deal with the power imbalances that exist. And I see folks here from BC Legal Services Lab. Want to thank you for the work that you're doing. My sister's also an Eagle from BC Law School and committed a lot of her time to helping those who are indigent and helping those who don't have information, especially myself as a Haitian American, and just the language barriers that present themselves in court, all of the ways in which people are discriminated against in our system, and we know that it disproportionately affects women and women of color with children. And so making sure that we know and that people know that these leases that they get are negotiable documents. I have never signed a lease that I have not negotiated, and that's easier for me because I'm a lawyer, but I also let people I know that you never sign a lease that you don't negotiate, that you can redline a lease, that you can cross things out, that you can write words in. And I think that we just need to do a better job of letting people know of their rights and empowering people. Still, even times with my guidance, folks don't feel like they have the power to really intervene in a situation that the tenant and that the landlord has all the power. And so it's incredibly important that we stand in the gap and that we help tenants know about their rights and that we figure out how we actualize that knowledge that is too often not in the hands of our tenants, who often self-evict in a commonwealth that requires a judge to have the final say. So I'm happy to be here to be part of this discussion for my constituents, for the residents of Boston, for everyone who has needed a lawyer and hasn't found a lawyer, and anyone who has, had their housing really in jeopardy when they could have saved it. And so it's important for us to be talking about how we can empower our renters. Thank you to the administration for being here, to Councilor Lara for this hearing, and to my council colleagues for being here and doing this work.
Thank you, Councilor Lejeune. Councilor Mejia, you now have the floor for first round of questions.
So I just have a few questions in regards to kind of some rights, and this is going to be more financial. I know that in order for you to move in, you have to pay first, last, security. There's a lot. Sometimes it's enough to put a down payment on a mortgage just to be able to move into any place. And then when it's time to move out, there are sometimes some discrepancies in terms of how much money you get back on your security, if at all. So I'm curious, as we're thinking about this Bill of Rights, right now I've had folks who have reached out to our office, in need of like $7,000 just to be able to move into an apartment. And I'm curious, what, if any, as we continue to have these conversations, what opportunities does exist, if any, to help alleviate the financial stressors that involve even getting into an apartment as we talk about Bill of Rights? I know we can't play with people's money, but we're here. We can brainstorm to figure out what that may potentially look like. And I'm just curious what, if any, ideas you might want to share in regards to those move-in costs.
So thank you for your question, Councilor. Our office, the Office of Housing Stability, does have a financial assistance program that we provide that resource to constituents who are looking for move-in costs. We obviously want to make sure that there's a sustainability component, and I think the conversation throughout has been having a conversation with the landlord and feeling the agency to be able to say, I don't think this fee is appropriate. Can we narrow down this number to $5,000 as opposed to $7,000. And I think to Councilor Louisian's point, a lot of tenants don't know that they can actually negotiate. And one thing that my office tries to do is have those conversations with both tenant and landlord to say, I know this is a symbiotic relationship of sorts and that you need payment and that the tenant needs a place to live, but that doesn't mean that you have to make the tenant completely broke in order to move in and sustain housing. So we provide that resource, but also want to make sure that we empower our tenants to have conversations going forward, and also make them aware of other provisions that are actually baked in the law, Chapter 93A, which precludes unfair and deceptive practices by a landlord, given that they are essentially a business owner. So making sure that tenants understand that in plain language and not in the legalese that is Chapter 93A. So that's one provision or one resource that we try to provide.
Thank you. So I have one more question, and it's more around the accountability factor. I'm just curious, like, as we start thinking about the right to negotiate, the right to, go back and forth, can you envision a world in how we're able to hold ourselves accountable to this Bill of Rights once it gets implemented and, codified into law? Like, what type of mechanisms can you envision? Or have you seen in other spaces that have been used to hold landlords accountable to a document like this?
Wait for it to become solid.
There we go. Thank you. A lot of new things to learn working at City Hall. I would think one of the things we would put into a Bill of Rights is for any violation of that, any aspect of the Bill of Rights, a person would have a cause of action in court. I think that's just basic. They have a right to file a complaint and argue to the court that their rights have been violated and what sort of settlement or they're looking for, unless the city council in its wisdom decides to set up an administrative procedure where those complaints could be filed. City government could do that as well. It doesn't have to be decided in a judicial setting. It could be decided in an administrative setting, which is exactly what we do with the Fair Housing Commission.
Yep.
So I think the city council has some avenues you should think about which way you want to pursue that. But people do need a place to go where they can get justice if their rights are violated.
Yeah, no, you have your light on, you want to? Yes. Yeah. Thank you.
Solid, got it. I just wanted to chime in on that. So I mentioned earlier, prior to your arrival, Councilor Mejia, we have the Housing Stabilization Notification Act, which requires landlords in the city of Boston to submit their notices to quit to our office. Violation of that would be a $300 fine. And I think in tandem with working with the Office of Fair Housing, nothing gets your attention more than a $300 fine. So I think figuring out ways that we can actually make landlords a little more accountable in terms of the practices that they are engaging in would be helpful in terms of making sure that we are in compliance with the Bill of Rights.
No, I appreciate that. One more thing, Councilor Lada?
Yes, you have 1.5 minutes.
Okay, thank you. Yeah, I think that one of the things that I'm really hoping to see more of here in the city of Boston is for people to understand their responsibility and how they do business here. And I think that we don't have a lot of tools at this point to leverage in terms of what accountability looks like, so which is probably one of the reasons why people are able to get away with as much as they do. And I think that, I'm all for utilizing every lever for accountability, because I think that if a $300 fine is a good place to start. And I also think that there's opportunities for every day that you neglect to clean somebody's property or to take care of the rats and the mice and the roach infestation, all of those things, that there should be a level of like putting some metrics in place for taxing people for their neglect. I know that sounds crazy and this probably will go viral, but at the end of the day, there needs to be some accountability here, because otherwise people are just going to keep showing up in ways that are incredibly dismissive to renters. So I think that, as hard as we can go to help support our renters, I am here for all of that. Thank you.
Thank you, Councilor Mejia. Councilor Lujan, you now have the floor.
Thank you. I'm just thinking a bit about what Director Terrell, what you said about lawyers. Unfortunately, not all law firms have the requirement that folks perform pro bono hours, right? That should be a standardized requirement to make sure that we are getting their time to do work on behalf of the people. That would be a good thing. I know that the Office of Housing Stability, is it every week or every other week that there's a clinic where there's free legal assistance for both landlords, small-time landlords, and tenants. If you could talk a little bit more about what that looks like, how that's staffed. Is it under-resourced? Do you feel like it's efficient in helping tenants get access, the kind of access they need? Where are the gaps there?
Sure. Thank you for your question, Counselor. So you're correct. Our legal clinic runs every week, every Tuesday from 5:30 to 7. It's virtual currently. We work with attorneys from Greater Boston Legal Services. We currently have 2 attorneys that join the clinic. And then we also have a mediator that joins us from Justice Start, which is a mediation company out of Cambridge who we contract with through the city. And they're able to have conversations with landlords. Sometimes we have landlords that come on with their tenants and are looking to come to some sort of resolve without having to go through the court process, because I do think some landlords know that filing a summary process action can be expensive, and it can take a lot of time as opposed to just sitting down with a neutral party and having a conversation. In terms of staffing and resources, we could always use more resources, but I do think given the turnout that we have amongst different neighborhoods and constituents, we are doing pretty well with the clinic, but I would welcome different ideas from the council and my co-panelists of how we could better reach other constituents who may not have the digital access through the virtual format. But as it stands, we still run it every Tuesday and still coordinate with Greater Boston Legal Services.
Thank you. Is there like a type of tenant or demographic that you feel reaches out and uses the clinic more so than others, and what does that show you?
Sure. I think constituents who have better access to internet are contacting us a little bit more tenants who are a little more affluent than others. So we get a lot of tenants from Councilor Braden's district. So trying to figure out how we can narrow our scope a little bit more to other areas, Mattapan, Dorchester, Roxbury, where we're actually seeing the highest eviction rates in the city.
And do you think that are folks using it who have language barriers?
We have not had any language barrier issues, but we do have accessibility to interpreters if needed. We have Haitian Creole speaking staff, we have Spanish speaking staff, we have Cape Verdean speaking staff. So we have that access, but we haven't had constituents who have signed up and said, I need this type of interpreter. So there's also that gap as well.
Yeah. Okay. I appreciate that. It's always going to be like how do you make sure this is getting in the hands of those who need it most?
Right.
Right. So like I'm here at City Hall, I'm a lawyer. Folks know that. When folks here and their staff looking at their leases because they know that I'm here.
Yep.
They know to reach out to me, and folks in community who know.
Right.
But there's always that gap.
Right.
And I wonder if a model could be to take that clinic out of the virtual mode.
Yep.
And if we want to make sure that people in Roxbury, Mattapan, Dorchester, where we're seeing the highest number of evictions,
Right.
know about the legal assistance that will really attack that information asymmetry, setting up shop like visibly, which sometimes I go back and forth about the value of physically seeing. I just did a job fair on Saturday that I didn't think anybody would come to because we were on Morton Street, right at Morton, across from Dunkin' Donuts. But a lot of people were coming through because it was right in a high traffic area that Black and brown folk use every day.
Right.
And I think even if you do some of those initially, it doesn't have to be consistent. I mean, it doesn't have to be the plan forever, but at least popping up in those areas so that people can memorialize somewhere in their brain that, oh, this is a service that exists. Maybe it's not always here, but I saw it this one time. So I encourage that, like going out in community and having pop-ups there, because I think that would be incredibly helpful to letting people know. And then the fight about resources and getting more assistance, I think we fight that fight. And then we do the work that Director Terrell is talking about and get all of the wealthy firms, all the folks who are here with their resources to be able to get their lawyers once we show that there's an increasing need, right? People are, Chapter 257 is about to come to an end and everyone's up in arms as they should be. And there are other things that we should be doing with all of the wealth and resources that we have, all of the lawyers, all of the attorneys in this city. So it's a travesty that Chapter 257 is going to end. And there's more work that we can be doing with the Access to Counsel Coalition that I know the city of Boston is a part of. And more ways that we can really meet people where they're at. And I think that's really important when we're talking about people who are facing housing instability, kids whose educations will be disrupted as a result of evictions. And so I just encourage that we root ourselves in community. Thank you.
I just want to say thank you for that. I agree.
Thank you, Councilor Lujan. And so I'm going to start with my first round of questions. I want to say two things just to help us really anchor the conversation that we're having today. There are rights that tenants currently have. There are rights that are afforded to them by the state. There are rights that are afforded to them by the city. And there are multiple ways, based on the conversations that we've been having so far, that we can strengthen them and increase access to the rights that people have. So that is step one, what already exists. How do we make those things accessible? How do we fund them? How do we make sure that everybody has access to what is already there? And how do we centralize them and communicate them so that everybody knows that they have the rights that currently exist? This is also a visionary activity. Where do we go from here? What is the world that we want to imagine for our renters and for our tenants? What does it mean? What does it look like? How do we ensure that people who are renters, which is the majority of the people in the city of Boston, have a dignified experience when they are looking for housing, coming to agreements about housing, making complaints about housing, and living in housing in the city of Boston? So we have had a number of conversations here on the city council about how we can protect tenants, how can we improve quality of housing. And what I would like to hear from anybody who is willing, and I have a list of other questions as well, but anybody who's willing to share here is, what is missing that is not already there? What would it look like to expand the universe of protections for our renters in the city of Boston?
You're going to get me in trouble. Well, I'll go out on a limb. I think all too often when we talk about housing in any context, affordable and otherwise, we really talk about housing as a commodity to be bought and sold. We think of it as a commodity within a free market system, competitive system. But for most folks, housing is not seen as an investment, it's seen as a home. I think there's a difference between having a home and having a piece of real estate. I think those are two very different concepts. Unfortunately, in our legal system, they're not differentiated. Also, because it's thought of as a commodity to be bought and sold and invested in, and as often as we've seen with the banking crises that we have every once in a while, it's a conduit for other kinds of investment, stable and unstable. At some point in time, we're going to have to decide whether all of the housing in our city is subject to those kind of market forces, and whether or not a portion of our housing market should be taken off the speculative market entirely. And it's seen as a public resource, even better than that, a human resource. Every once in a while, there'll be a push, and I think there was some discussion in the council about this a couple of years ago, whether or not housing was a human right. And I believe that it is. That's just my own personal view, not the view of the administration, at least not yet. Maybe it is. I hope so. The further I get out on the limb.
We'll check.
But given the fact that the private market, ever since the Great Depression, has admitted publicly numerous times that they cannot house all of us, that the cost of production is prohibitive in every generation, so much so that given the income distribution that we have in the society, there are just going to be some folks who can't afford it and some folks who are not going to be well housed. So at some point in time, we're going to, as a society, we're going to have to decide how to create a more differentiated housing market. One that is highly speculative. If you want to play the speculative game, go ahead and do that. But if you don't, or you can't, or you feel that you shouldn't, then there should be another portion of the housing market that's set aside for people who simply want a home and a place to live and not a vehicle for investment. And you can choose which way you want to go. And you don't have to stay in either one permanently. You can go back and forth if you wish, depending on your circumstances. Now, this is not a completely theoretical proposition. In my neighborhood, Dudley Street Neighborhood Initiative, on their land trust, has affordable home ownership. It is essentially limited equity. Some people in my neighborhood would object to the limited equity portion of it, but the idea is to be able to pass it on to the next generation. Because if you allow the speculation to take place, the next generation won't be able to afford it. So the idea is to rotate that resource generation after generation, so at least a portion of our community is housed. And it's been working very successfully. Why don't we build on that model and see if there are other parts of the city that would entertain having such a housing strategy, and at least start there. But until we confront that, we're going to continue with this housing crisis that's been going on for at least 100 years.
Thank you, Director Turner. Director Johnson?
Oh, you had your light on first, go ahead.
I think it just stayed on, but
Oh.
So I have a couple of thoughts, and I hate to tip to the looking at the state level as well, but just I'm thinking of Councilor Mejia, your comments on some of the upfront costs, and I do think that we have an issue with real estate brokers in terms of both the fees that are assessed as well as it's very difficult to take action if someone has engaged in discriminatory practices and they're a broker. So there has been some efforts to address that, and I think that that's something that deserves a lot more attention, both on the upfront costs, which I think may be superfluous, and ensuring people are behaving equitably. And it does relate directly to the BHA, actually, because one of the primary constituencies that does get discriminated against is Section 8 voucher holders who do have in Massachusetts and in some states, they are protected under fair housing law, as my colleague well knows. But realizing that right can be difficult. So I think that figuring out a better way, and if there are municipal angles, obviously that would be wonderful to do, or educational efforts as well. And hopefully at some point a shift in state policy around real estate brokers, I think would be really beneficial to both treating people fairly and to as well reducing some extraneous and superfluous upfront costs that I think restrict people's choice of where they can live. I think we have in this city, we do work within the housing authority to inspect unit quality of ours, of other renters who we have provide rental census to. If someone has a complaint with us, they could go to ISD, so there's another party as well. So I think people can avail themselves of multiple channels. I think when we think about some of the other major priorities that the city has around, for example, public health, environmental justice and whatnot, and think about what's the incentive for a landlord to improve their property in the same ways. We do some health inspection, but it doesn't, thinking about how some of the benefits as we're trying to improve indoor air quality, as we're trying to reduce people's energy bills, I think efforts to really include, even in smaller properties, to make sure tenants receive those benefits is going to, I think, be very important.
Thank you, Mr. Wu.
And that's a great segue, Joel, because I was going to make a comment around getting the judiciary involved as well. There's a Mass Access to Justice Commission that focuses on these very issues of access, who has and who does not. So I think focusing, when you're asking what's missing, and that goes to Councilor Lujan's response regarding who are we accessing and who are we not, figuring out that piece of, I live in your district, Councilor Laura, in West Roxbury. There may be less access issues there as opposed to in Mattapan or Dorchester, but the access may be different. There may be folks in West Roxbury who don't have the digital access or the digital acuity as opposed to other neighborhoods. So understanding the access points and figuring out how we can connect with folks that way.
Thank you so much. And I'm glad now that you've confirmed that you live in my district. We were on the panel at the BC conference, and every panelist was a District 6 resident. All of the panelists were District 6 residents. I know, but completely by chance. They all introduced themselves, and they were like, and happy to be here with my counselor. Everybody lived there. There was 4 of us, and everybody was a District 6 resident. So I thought that was funny. I didn't know that you also lived in the district. So I'm going to do kind of a thank you for that, because I think that this is, kind of like one of the overarching bigger picture. I'm going to do kind of a lightning round, and I'm going to move us through the process, and maybe some of the 5 principles that some of you have already talked about, but that are mentioned in the white paper that was put out by the administration. So leases, right? First of all, there's discrimination when you're looking for housing. I cannot tell you how many times somebody sends me a screenshot of a Craigslist post that is like, no lawyers, no, so on and so forth. And so when I'm not sure what our avenue is, right, to kind of hold those kinds of people accountable or where we are, but there is already housing discrimination that's happening. People's rights are being violated while they are looking for housing before they even find an apartment, right? Now you find an apartment, I've heard the right to negotiate, right? Doctor, you brought it up. It's been brought up multiple times, letting people know that that's a contract, that they can make changes to it, X, Y, and Z. A lease. Are we currently required to provide leases for people in the language that they speak? No. Yes? No? We don't know? So if somebody doesn't speak English, you are not, you could, right? Oh, if they request it, but it's not required that a landlord gives you a lease in Creole, Spanish, so on and so
I
forth.
don't believe so.
Okay. So in addition to that, and I think that this is the common, and this is one of the things that we've been thinking about, is that we have a common applications for colleges and universities. What would it look like to have a common lease for the city of Boston that really outlined at the beginning of the lease what your rights are as tenants before you read out the lease, right? First 2 pages are actually all of the rights that are afforded to you as a tenant in the city of Boston, and then the lease. The reason why I bring that up is because, we've talked about legalese often, right, and how inaccessible some of the language is. If you are a communications person, then you know that if you want accessible language, it needs to be written at an 8th grade level. That is not at all what we see in the leases that come on here. And so we are not even requiring that the language that is on the lease is accessible and understandable to the person that is rented. So there are some things there in the process for requiring people to leases. Now the next question that I have is for you, Mr. Wu. Because BHA manages all of their properties.
We manage most of our properties.
Most of them. So you do bring in management companies
Yes.
to manage the outside companies.
Yes.
So I've also, some of the issues are with the management companies, right? So it's not always with the lease. We're talking about the management companies and how they're overstepping. I have heard complaints from people who live in public housing where the management company has told them that they are not allowed to ride their bike outside of their building, that it is a violation of their lease, Trinity, if you, for the record, and are giving people one violation for sitting outside of their building and riding their bikes in the common areas outside of the housing developments. So
I would love to just do a brief clarification on that.
Yes.
So there's, we have public housing, we own the building, we own the land, we manage it. We have public housing, we own the building, we own the land, it has a private management company.
Yes.
Then we have redeveloped properties. It's affordable at the same rental level for however many public housing units were there. It's a private owner, and we own the land, and the tenant's rights in that case are asserted through the ground lease that we have with the private owner. So there's the redeveloped scenario. So the point at which we capture where BHA is not the owner of the building is during the designation of the developer and sort of the redevelopment process that follows. And that's something where we worked recently with Greater Boston Legal Services and City Life and some other parties. Health Resources in Action, I think, funded this to try to kind of come up with concepts for tenants' rights in public housing redevelopment. So that, I think, is a recent evolution, which is not dismissing the individual issue.
no,
I just
you
mean
know,
that there's
this is
been
absolutely-
some progress there,
Yes.
and there are opportunities to intervene kind of at the point if a property is being redeveloped.
Yep. Yeah, and that's actually really good clarification because, you know, obviously there's work to do at BHA, but I think that tenants are very clear, at least in my communications with them, that it is the management company.
Yeah.
They'll say this management company, that management company, organizers, people who are, like, they know who the problem organizations are and the problem businesses are. So
Yeah.
just wanted also to clarify that. So how do we communicate people's right to organize to them, tenants' rights to organize to them? We do not? Yeah, let's get that on. This one here? Juan, can we get a microphone? There we go.
Okay. I know for us during our legal clinic, that's one thing that we have a section on of if there are a host of tenants that are coming from one singular building, we put them in a room and have them have a conversation and let them know that you have a right to organize. We also work with City Life Vida Urbana as well and send constituents there, again, if there's commonality of complaints. But outside of that, there is no uniform, here is your right on organizing. So I think that is definitely something that we could insert into the Bill of Rights to, again, ensure that tenants are aware of their agency to contest any issues within the properties that they live in.
Yeah. And so the right to organize is one of the things that's already afforded to them, but is
Yep.
not being communicated, so people don't know about it, and also is not, I don't think at least is being properly resourced. Not only within the city, but how we're resourcing community-based organizations who are organizing tenants' unions as well. So there's a gap there. So I'm going to stop because I have a few other questions, but I want to do a final round before we move on to the next panel. So Councilor Braden, you have the floor.
I think we've talked about many issues. I think as we go forward, we could hash them out more detail in a working session. The issues about the upfront costs are really critical. Like, it is prohibitive and puts folks under incredible stress. So I think that's another moving piece that's another piece of the puzzle that we have to sort of address with regard to broker fees and deposits and security deposits, and then knowing how and knowing that it's in an escrow and that you're entitled to get the interest on, not that there's much interest, or there hasn't been much interest on these accounts, but that you're entitled to get a statement of the interest, etc. So many of our tenants don't have that understanding. I also feel that, you know, it's really important to understand the balance of rights and responsibilities on both sides of the contract, and make sure that, you know, it's that transaction that, because we're in this sort of really seeing housing as a what did you call it, a commodity, that you want to maximize your profit from this asset that you have. I think we need to move away from that and seeing that it is a public good, and it's really important to ensure that that our tenants have dignity and rights that are respected, and that they have these opportunities to organise and make everything better all across the board. My one big concern in our environment in Alston, Brighton, we have, and I'm sure other districts have the same problem, we have a huge number of absentee landlords. We have no idea who owns the building. It's an LLC. You go looking for who owns it. There's no, that idea of being able to contact the owner of your building and make a direct complaint is another part of the puzzle. Because even as representatives of our constituents, we're trying to follow this, find the owner, trying to get something addressed, and it's been really, really challenging. And I don't know if you have any solutions. I think this is again an issue at the state level. We have to sort of take the curtain away from who are these people, who owns these, and what are their responsibilities to their tenants. It's not just a big ATM. Their property is not an ATM to just generate profit. That money is taken out of our neighbourhoods and goes off somewhere else, and that money is not spent in our neighbourhoods. So it's detrimental to our communities at large, rather than and it's a money-making profit enterprise that. And housing should be a public good. So, any ideas about the absentee landlords and the LLCs that we have no idea who they are?
Well, in the past, when I've had to research something like that, I found the records at the Secretary of State to be very helpful. They're very clear about who created the LLC. Now, sometimes what they'll do, they'll say that the LLC is owned by another LLC. And then you have to go through the corporate chain to find out actually who it is. Also, some of the property tax records are also very helpful, because when they pay their property taxes, that check came from an account, and that account is owned by somebody. And we can find out who that somebody is. So there are several different ways to track down ownership.
And I'm sorry, go ahead.
No, I'm done.
I was going to agree, but I think the point is, and I don't want to sound like a broken record, is access. Do many tenants know that they can look on the assessor's website, that they can go to the Secretary of State to figure out who the owner is? So creating something where, and I don't think that tenants should have to do this sort of scavenger hunt to figure out who their landlord is, but equipping them with, okay, the landlord is MIA at the moment, here are the resources, go to the assessor's website, go to the Secretary of State's website to figure out, okay, who is the person that is alleged to be the owner of this property. So that is one mechanism, but that doesn't resolve the issue of making sure that tenants know exactly who they're renting to. And to your point, Councilor Braden, that this isn't a money market, that we should be able to have these conversations with actual individuals instead of a LLC or an email address.
Thank you. Thank you, Madam Chair.
Thank you, Councillor Braden. Councillor Mejia, you have the floor.
We all go through the blinking light situation here. So, unlike Councilor Louis-Jean, I am not a lawyer. but I have navigated the court system as an advocate. I remember working with a woman who was transitioning out of DTA, and I was doing workforce development. But I ended up becoming a housing advocate, and I felt like Erin Brockovich, trying to figure out how I helped this woman. I didn't even know where to begin. And I just remember how vulnerable and how scary it was for her and her children to have this over her head that she was going to get evicted. And I felt powerless, even though I was an advocate. And I think that as we continue to have these conversations, the more we can humanize that experience as how people are going through this process, the stronger this Bill of Rights is going to look like, right? And who it is that we're here to serve. So that's why I'm so incredibly encouraged by this conversation. I think that one of the things that, if I remember, this was probably like 12 years ago, so forgive me, but I believe she might have been also a voucher holder. So there's two different sets of, when I think about BHA, there's like the housing developments, but then there are also the folks who have mobile vouchers. And so I'm just curious, as we're talking about the Bill of Rights, what rights, when you have a mobile voucher, what rights can BHA support these folks who are subleasing, I guess, if you will, from a landlord? Is there a relationship between BHA and the landlord?
So we absolutely have a relationship between BHA and the landlord, and they have to abide by that contract in order to receive rental assistance payments. We have limits, like if they want to remove a tenant from their property, evict a tenant from their property, they can terminate that contract, but there are ways in which the protections come into play. So one issue I mentioned was inspections, right? People have to meet not just the city's code, but the standard, if it's Section 8, the standards, housing quality standards. So we have our own inspections department. There's also just a process for when people in the voucher programs request rent increases. So if people improperly notice, if they don't work with BHA or they improperly notice that between BHA and the tenant, they cannot just push through rent increases. So there's some control and costs through that vehicle. We have a relationship, so we try to engage if we get appraised of other things that would destabilize the tenant's housing. Sometimes people do also contact us they're afraid of their landlord and they want to move, and we don't have extensive housing search services. It's not something we're particularly funded to do, but we do try to work with OHS in particular and some of their vendors when that happens. So there's a little bit of what are the rights, and they exist, but they have limits, right? We don't, because we are not the property owner, we cannot compel, a certain resolution. But if people do not abide by their portion of the contract, then, then we have some ability to engage.
Thank you, Joel. And I think that, when we think about levers and we think about what, tools we have in our toolkit, I think that if, so my mom was a mobile voucher holder, and she lived in the same triple-decker for, decades. But every year during recertification, she would have to go in and present how poor she was so that she can continue to keep her voucher. But the conditions in which she was living under were just as equally as poor as she was. And, the landlord was asked to exterminate, because there was a roach infestation, there was roaches and mice, and it was crazy how many different little mice traps we had to put around the house and how many mice we killed. But we still lived under those conditions, right? So I do think that as we think about rights and as we think about quality of life, that there is a role that BHA can play in helping to strengthen some of these conditions that people are living in, because you get what you get and you don't get upset. And that's the type of condition that I grew up in. And I think that as we continue, because we are also in many ways, a lot of these landlords don't even live in the city of Boston or even in the state of Massachusetts, and yet they are profiting out of BHA vouchers. Mm-hmm. and they're driving rental costs. And they are, in many ways, getting a pass in how they treat their renters. So I'm just curious, as it relates specifically to BHA, what are some of the ideas that you can share with us in terms of how we can strengthen the Bill of Rights as it relates to landlords who have BHA residents?
Well, I think, so I mentioned voucher discrimination before, so that's both people who have a residence and also people who refuse to rent to them, right? So that's one of the, so in cases like, your family, we want to be thinking about both people where they are and where they're looking to live. As I mentioned, the follow through on this is obviously what counts, but inspections, we do terminate contracts with landlords because things don't meet code. The issue is we don't want to destabilize tenants either, right? So then people will, if I can't provide subsidy to that unit, sometimes people, they don't like the condition of their unit, but they want to stay in place anyway, right? So we try to be really careful in how we engage there, because if we're like, this is not a great landlord, their house is not up to code, so we can't subsidize you living here, then the person is removed from, they are dislocated from their place. And that's difficult, but it's a bit of a balance as far as, ultimately the inspectors enforce what the standard is, but we just want to be careful about how over what period of time we work with people so that we can get repairs done at the properties, or have landlords do that rather, or if it really is necessary, make sure people have the opportunity to find somewhere else, right? But I just wanted to mention too, right, this is obviously an interactive thing with ISD, who is not represented here, and I cannot speak for them, but in terms of the registration of private market rental units, right, that's the agency, I believe, that is still responsible for that. That's, I think Boston probably started doing that 8 or 10 years ago. It's not that long ago that this, the rental registration was put into place. And so there's a level there, because that is it has certain obligations, right, that is, would be applicable, I think, to units that we have voucher holders, as well as, and I think this is important, creating a uniform standard, right, for units. That is, there's certain housing code requirements for that the building commissioner, in other words, ISD, enforces, and that the rental inspection helps achieve.
Yeah, thank you. And one last question, and it's more about kind of how we navigate the space, and I'm just curious if you could just talk to us a little bit about folks who are who call ISD, or who are trying to find some sort of reimbursement for the medical bills that they've had to pay because of the conditions that they were living in, right? I'm curious, like, who is accountable to that? I've had some families who have stayed a few days in the hospital because they were impacted by the mold. Like, is there some sort of mechanism already in place where the landlord is held accountable to helping to support with medical conditions and costs that are associated with negligence?
What I would say, I can really only speak for our units, but if there is a scenario where we don't feel like we have provided the quality of housing people deserve, that they have been able to demonstrate consequences, there are instances in which we have supported tenants there, and we, that's not, I think, a common scenario, but it's something that we support people in that way.
Thank you. I don't know.
Oh, well, I just had a thought that under the state health and sanitation code, people could go into housing court and file a complaint against their landlord for bad conditions. Once again, the courts, once again, the need for counsel, it all comes right back around.
Councilor Mejia. Councilor Lujan, you have the floor.
Thank you. Director Terrell, there are two things I wanted to mention. One, thank you for bringing up Dudley Street Neighborhood Initiative. I think supporting community land trust and alternatives, that's why I'm a big fan of the city's acquisition opportunity program that allows us to take some of that housing off of the speculative market and really stabilize tenancies in place. So I want to thank you for that. You also mentioned, or I think you had, when we were talking about housing discrimination, especially, the housing discrimination that presents itself when people are engaging in the housing search to begin with, as I think Mr. Wool also spoke about. We talked about getting more testers for your department, which is crucial in both the rental and the ownership spaces. I hope that, and hopefully there's space for this in the budget to not only hire the testers, but to also do a public awareness campaign around the fact that we are hiring testers, to put landlords and property owners on notice that this is something that the city is watching for, so that we don't hire the testers silently, that is something that we do as publicly as possible, so that folks know that this is an issue that we are trying to root out and address. So I don't know if if that's been part of the plan, but if you want to speak to that.
Even before I joined the administration, and when I was asked what changes I want to bring to the commission, I think the first thing I mentioned was bringing testing back in-house to the commission. This is actually my second go-round with the commission. And when I worked there previously, we had our own in-house testing program. It serves a couple of advantages. But the most important is, when we don't have testing, we have to rely on circumstantial evidence. With testing, we have access to direct evidence, which makes our investigations much more robust, much more detailed. And I am convinced that some of the cases that we've had where lack of probable cause was found was because of the lack of direct evidence. That we would, in fact, be finding even more discrimination if we had access to that kind of evidence through testing. So it is my intention, and I hope to get the council's support for our budget going forward so that we can accomplish this, but to have our own in-house testing program so that every complaint that comes through could be, time willing, subject to testing. When I ran the Fair Housing Center of Greater Boston, that's exactly what we did. We pretty much tested every complaint that came through. And it made our enforcement of the Fair Housing Act and other civil rights laws much easier to do. And we can test, when you talk about sort of a robust recruitment effort, that's absolutely essential in fair housing testing because we test for all protected classes. So we need all sorts of folks in our testing pool because we're testing for everything. As a matter of fact, when I worked at the BHA, there was some BHA staff that wanted to become testers. I'll be coming back to them.
Thank you, Director Terrell. You have my support. I think in-house testing is essential. You see it, there's discrimination taking several different forms. Either some people are charged a broker's fee and others aren't, I think, which is also the work of this council that we'll be talking about eliminating broker's fees in the process here because for many reasons, but one is because of the discriminatory application of broker's fees and of security deposits, right? I think Councilor Braden spoke about your right to have those security deposits in escrow and accruing interest, and people don't know that once you get to court, if your landlord takes you to court and they haven't done that, them failing to escrow that security deposit is one of your biggest offenses, where you can get treble damages and attorney fees, right, 3 times. So I think that, that's a bit of away from testing, but I think the testing, in-house testing component is going to be incredibly important. And Mr. Wool, you talked about, I think you mentioned that realizing I think you highlighted something that's really important, that realizing their rights, tenants realizing their rights can be the really difficult part. And there has to be an access and enforcement mechanism to tenants being able to realize those rights. So curious if during your time at BHA or your time here on the council, you have any insights into what the city itself could be doing better to help tenants realize those rights. Because I know that you were here, your housing was a major part of your portfolio, and you saw from the constituent services perspective, but wondering what we can be doing better from City Hall in terms of helping tenants realize those rights.
You know, the individual I worked for when I was here also held this role, and I have tremendous respect for what Office of Housing Stability does. And I think that, you know, you had asked some questions about other ways to resource that and expand it. So I'm a big believer in meeting people where they are. So I don't know, Counselor, if I'm the expert on this issue, but what I would say is just that I think also, I think the chair referenced sort of like the lease terms versus like plain language explanation of things in people's language, right? Mm-hmm. So I think having more material and discussion, 8th grade reading level in the language someone knows in their neighborhood, right? And making sure that if that's a city staff obligation, that we have provided that. And I can say this because I'm not a city department, right? So we provided the resource to whomever would be doing that. I think that could be quite helpful. I mean, and I do think the Notification Act that various, I think, generations of OHS leaders have worked on has been really important, and it's kind of a way of innovating a little bit, because where we have a limit in our ability to municipally regulate property law or landlord-tenant relations, it's attaching information to it. So I think, is there any way to build on that kind of thing where it's a guaranteed right, people don't know about it, can we include it in what maybe is provided to people through one means or another?
Thank you, Mr. Wool, and thank you to everyone. Thank you, Director Johnson. I have incredible respect for the amount of work that you do at OHS. So that question was meant to, how do we further support? You get inundated with so much, and I just want to say thank you, because I know you work around the clock for all of the tenants who come knocking at your door, who need help with rent, who just have a question, and we also send them your way. So incredible amount of respect for the burden you carry for the city. So thank you.
Thank you, Councilor Lujan. And so for one moment, I'm actually going to take us out of order. We have some public testimony that is going to be leaving us at 12 p.m. So we are going to move for the next couple of minutes to public testimony. And we have Michael Wiper and Cassandra Dimitri. Is that correct? Beautiful. So right here on the left-hand side, there is a microphone. Please introduce yourself for the record. Right? Yeah, this one in the podium. In the back? Yep, right here.
Madam Chair, before you proceed, I'd like permission to be excused. I have a 12 o'clock meeting with the member of the Equity Cabinet, so unfortunately I have to leave you. But thank you for the invitation, and I learned a great deal today.
Thank you so much, and no worries at all. We're going to be closing out the administration panel right after this, so right on time.
Thank you.
Thank you so much. So again, once the director transitions, please introduce yourself for the record, and you have 2 minutes to give your testimony. You have the floor.
Good morning. My name is Michael Wiper. I'm a member of Boston College Legal Services Civil Litigation Clinic, and we specialize in one area in housing cases. And I'm here today to support the Renters' Bill of Rights. A universal set of renter rights and landlord obligations presents opportunities to address specific problems that could be remedied but are often overlooked. The education and enforcement of these rights is especially critical in urban areas like Boston, where proportionally more people rent and housing stock is limited. Consequently, landlords have enormous leverage. For renters, this fact, combined with the lack of knowledge of their rights, can lead to dire consequences. My clinical experience has shed light on one of these consequences: detrimental impacts on victims of domestic violence. Due to their natures, housing law inevitably interacts with domestic violence issues. For example, Boston College Legal Services recently worked with a client and her 2 young children who were actively fleeing domestic violence while facing an eviction. Due to the client's lack of knowledge regarding her legal rights and the varied locations of domestic violence protections in state law, the client was unaware of critical protections that she and her children had relating to the housing matter, namely the right to end her lease without repercussions and escape the ongoing abuse. As a result, her ability to flee the situation was greatly and unnecessarily hindered. My partner and I received this case only 6 days before our client was scheduled for an eviction trial. However, our client was not at fault for this last-minute situation. Until mere weeks before trial, she was unaware that there were any late rental payments and that eviction proceedings had been filed. Her former partner, who was also her co-tenant, co-defendant, and the individual carrying out physical, emotional, and financial abuse, was the only tenant receiving notice from the landlord regarding late rent and was not informing our client of the proceedings. To make matters worse, around the time she learned of the suit, the domestic violence issues escalated to the point that she obtained a restraining order. Nevertheless, she was unsafe and sought to move her and her children to a new apartment to gain security. However, the open case against her hurt her ability to flee, as her name was publicly listed in an open eviction matter when landlords searched the housing court docket when she was applying. As a result, the client was caught in an unsafe place through no fault of her own and was unaware of her legal rights. Ultimately, our involvement was needed for the client to learn about specific protections relating to individuals fleeing domestic violence. Only at this point the client learned of and exercised her rights, allowing for the case to be dismissed and all back rent forgiven for her. However, renters should not need a lawyer to know and exercise their rights. Our client and her children are now physically safe. However, so much went wrong unnecessarily before the matter was resolved. The experience opened my eyes to how a clear set of universal renter rights could have prevented much of this stressful and traumatic situation. First, our client was not aware that she had a right to break her lease as a victim of domestic violence. This knowledge could have enabled her to get out of the lease and out of the apartment much earlier on, perhaps before the suit was even filed. Later on, exercising this right was critical, as we were only able to obtain dismissal due to the successful breaking of her lease. Conveying such a powerful right through the Renter's Bill of Rights is a critical and necessary step to ensuring that key protections are accessible without a lawyer the moment a tenant may need them. Furthermore, the public nature of eviction matters is tremendously harmful to the health and safety of tenants, as it makes it more difficult to secure housing moving forward. It is often unfair as circumstances outside the renter's control, as in our client's case, resulted in the initiation of many housing proceedings. Therefore, a universal right for tenants navigating the eviction process, for which they may not bear any fault, should be that the records are sealed both while the case is open and after it is closed. This would be critical to protecting against the cyclical nature of housing instability that so many tenants and families in Boston face. For these reasons, I support creating a Renter's Bill of Rights for the City of Boston.
Thank you so much. Hello, good morning. Please state your name and affiliation for the record, and you have 2 minutes for your testimony.
Thank you, Chairperson Lara. My name is Cassandra Dimitri. I'm a second-year law student at Boston College Law School, serving as an SJC Rule 303 student attorney. In my work as a student attorney in the Civil Litigation Clinic, I've had the opportunity to represent and counsel vulnerable clients facing eviction in Boston. In the Commonwealth, the vast majority of tenant defendants are pro se. In my experience, this is the same in Boston. Since there is no right to counsel in these cases, the creation of a Renter's Bill of Rights is even more important. My experiences advocating for these clients have revealed a vital gap in resources for understanding and assessing a renter's rights and responsibilities. Such resources are limited and inaccessible, leading to exploitation and mistreatment by property owners. Housing security is tied to so many areas of an individual's life. While working with a client relating to a family law matter, I learned that the client was also facing eviction. Not only were the eviction claims against him not meritorious, but having to cope with the prospect of losing his home was so stressful, it upended other areas of his life. The threat of eviction interfered with productive employment and active parenting to his minor children. While he knew he had paid his rent obligations, he was unable to navigate this complicated process by himself. Speaking to my client days before the summary process trial, he was exasperated and could not even think about his job or children until after the eviction proceedings. A day before the summary process trial was scheduled, the counsel for the management company filed a voluntary dismissal. My client appeared pro se in this matter for several months. Dealing with the eviction matter was so confusing and time-consuming. The management company continued to overwhelm my already distressed client with threats of eviction and court appearances. Only when he had obtained counsel did they evaluate the merits of his case. My client faced a vital barrier to accessing the legal rights he knew he had as a tenant, but he did not know what those rights were, let alone how to access information about those rights, and as a result, could not assert them. The creation of a renter's bill of rights would fill this information gap. While the matter has been resolved, the eviction process was so confusing for my client, and he did not have the tools himself to make the meritless eviction disappear. The opposing counsel proposed to postpone before they ultimately dismissed their case. The landlord would have continued to prolong the proceedings, continuing the confusion and powerlessness of the tenant-client. In my one semester of legal advocacy, I have seen large property management companies take advantage of powerless tenants. Without legal representation, these landlords likely would have succeeded in their eviction processes, leaving vulnerable families without access to safe and secure housing. The sheer volume of renters in the city of Boston demands further protections in the form of a renter's bill of rights. I urge you to make sure that 65% of the Boston population is covered by the proposed Renter's Bill of Rights, a comprehensive and accessible legal document for tenants to protect themselves without securing counsel.
Thank you so much. And thank you, Michael and Cassandra, for being here with us today, and to the rest of the BC Legal Services Lab team. I have two questions before I close out the administration panel. One of them is, what is the most common violation of the tenants' rights that you see, either in your office or complaints that are coming into BHA?
Well, my mic is heating up. I would say the most common violation would be quiet enjoyment, surprisingly. So tenants that are being louder than other tenants, or for some tenants who have disruptive, and I use disruptive in air quotes, children, not knowing that the child may have disabilities that prevent them from being quiet during a certain hour. We also see random lease violations, fees being attached that aren't use and occupancy, so couldn't be used for reasons to bring a non-payment suit against a tenant. So I would say those top two would be the reasons for evictions, or at least for summary process actions to be started.
And both of those things you're finding are coming in as complaints that will not hold up.
They may or may not hold up. I think it's for the fact finder. Sometimes it ends in mediation, which can be great, but that also creates its own set of issues, because in agreements for judgments, you have a lot of tenants who sign not knowing what rights they're giving away. So I think it all depends, but usually in those cases, they end in agreements for judgment in the court.
Great. Thank you so much. Mr. Wu?
So when it rises to a complaint level, I'm assuming it's not a repair where it's like, for our properties, like someone's asked for a repair and then they feel like it hasn't been addressed, right? They've escalated once from that. Or it's a private landlord with a voucher, right? So I think
Well, sorry to interrupt, if the repair isn't a violation of the requirement by the building code, then it would be a violation. If it hasn't been repaired, then it would be in violation.
Okay, yeah. So, we engage with sort of a range of basic maintenance issues, and we try to pursue those. And I think under the current administrator, there's been a really concerted effort to fulfill that basic requirement of, safe sanitary housing. And when we hear about conditions that seem to fall outside of that, we try to take fairly targeted action. So I think that because you have many people living in some certain properties with for example, if there's a pest issue, we hear about it quite a lot. And so we work pretty actively on that. with, by bringing in contractors to address the issue, we have that on a running basis, right? So those are some basic sort of as a landlord things we hear about. We certainly hear about health safety issues in the voucher program. Some of them are like rodent pest issues. I would need to look to see what the most common is, but that's certainly one that people face. And again, we have, from an inspections basis, we work on that with the tenant and the property owner. I think we also, I just wanted to note, we have, people can avail themselves in BHA of rights that they have within our process, and then they can go to external agencies. So a basic right that tenants should have, right, and have with us is like some grievance airing, like in the same way, well, let me just say, there's certain elements where they're able to bring, to appeal certain decisions, to bring grievance, and that is done so that they can have their sort of the department they work with in that particular program, public housing program, admissions, and there's another department that can look at it that adds kind of a layer of, I would say, first of all, second level of civil rights protection to what we do. Beyond that, they then could avail themselves of outside agencies like fair housing or state commission. So I think we've tried to set it up in a layered way over time, over the history of agency, so that we can do as much as possible to be the best, entity possible, and then also enforce that where we have that relationship on private actors. And then, should people feel that there is something beyond that, there are additional agencies that can look at that issue.
Do both of your agencies collect the complaint information? What kind of complaints they are, what neighborhoods they're coming from? Do you have data on that?
So we use a database where constituents call and we put their information in. There may be a way to track it. I don't think we've ran a report necessarily on the types of complaints that we get, but I do think there is a way to extrapolate that data.
Okay.
We would track work orders, we would track appeals, we would track inspections issues on private units.
Okay. Thank you so much. That is all that I have. I'm really grateful for you all hanging in there with us today. Of course, you will hear more from me and other counselors and our office. And at this moment, we are going to let you go back to doing your very important jobs, and we're going to move on to our next panel.
Thank you.
Thank you.
For our second panel, we have Mark Martinez, the housing staff attorney at the Massachusetts Law Reform Institute, Alex Ponte Capellan, board member at City Life Vida Urbana, and Mary Statos, a tenant organizer at the Greater Boston Tenant Union. If you're here with us, please join us here. Thank you all so much for being here with us today. How you doing? Great. So I am going to start with, I'm actually going to go in the order that I called you all in. So we're going to start with Mark, then Alex, and then Mary. Is that okay? Perfect. So each of you have 5 minutes to give your remarks. Please state your name and affiliation for the record. And Mr. Martinez, you have the floor.
Thank you. All right, thank you. I want to start by thanking Councilor Lara for filing this ordinance and allowing me to speak today. My name is Mark Martinez. In addition to being a Roxbury resident and a renter, I am also a housing staff attorney at the Massachusetts Law Reform Institute. In this role, I not only work on a number of housing policies, I am also in housing court providing eviction defense to unrepresented tenants. A strong tenants' bill of rights is a crucial tool in the fight for housing justice, and I want to echo some of the comments from before and the optimism around the White House's recent release of their white paper on a tenants' bill of rights, and some of the things that I'll talk about today will overlap with that. As housing costs continue to rise all across the region, the power imbalance between tenants and landlords tips more and more in favor of the landlord. And the city has to act now to level that power imbalance and give tenants the tools and protections that they need in order to remain safely and affordably housed. It's a widely held belief that Massachusetts is a tenant-friendly state, and by extension, Boston a tenant-friendly city. While we do, relatively speaking, have more protections in a lot of places, that does not mean that we do not have a lot of room for improvement, and it doesn't mean that we do not lag behind other cities and states in a number of critical areas. One of those areas is, of course, rent control, but we've already had that conversation, so we won't talk about that right now. And this also goes similarly for just cause eviction protections, which I also testified on during the rent control hearing. So I'll save that for now, though I'm, of course, happy to answer any questions around either of those. In addition to those, I do believe there are a number of protections and rights that all tenants in Boston should be entitled to. All tenants should have a right to safe and affordable housing. This means city policies that promote the creation and preservation of affordable housing. This also means access to rental assistance funds to help families keep up with the skyrocketing cost of housing in Boston. And I would also include in here tenants' right of first refusal as a way to preserve naturally affordable housing in the city of Boston. And to some of the comments made earlier, this also means limiting the upfront move-in costs for tenants, including limiting brokers' fees or making it so, following the lead of some other cities, making it so the landlords have to pay for that rather than the tenants. Requiring tenants to have up to 4 months of rent prior to signing a lease in the second most expensive rental market in the country really is an insurmountable barrier for so many people in Boston. And this also means that the city needs to step up enforcement of sanitary code violations and increase funding for inspections and enforcement of that sanitary code. All tenants should have a right to education on their rights and the ability to enforce them. This means right to counsel in eviction proceedings. Housing court is not a tenant-friendly place, and beyond knowing your rights, you also have to know how to assert them with the correct procedure that the court demands, or you risk losing rights that are afforded to you. A task that's almost impossible without the assistance of an attorney. This also means the city should fund Know Your Rights training so tenants are actually aware of the protections that they have. And a part of this, as already discussed, I believe, is protecting a tenant's right to organize, and I've got lots of thoughts on that as well. And all tenants should have a right against discrimination. While this is already the law, steps should be made to enhance these protections and step up enforcement. This includes source of income discrimination against our tenants that have Section 8 vouchers, as Mr. Wool talked about earlier. Another discrete issue is the issue of both the state and the city have dedicated lots of money to rental assistance. There is no requirement currently that landlords actually participate in that process. And so even though things like RAFT can make landlords whole and pay rental arrearages, there is no requirement that landlords participate in that process. This also means not discriminating against people for their rental history. A large part of this is ensuring a right to eviction ceiling, which is talked about before. Let us be clear, every eviction in the city of Boston is a policy failure. And while we figure out how to remedy those failures, we need to make sure that tenants who have struggled to keep a roof over their head are not further penalized with an eviction record. And then this also includes strengthening protections for victims of domestic violence, which we've already had testimony on. I also want to take a quick moment to realize the special situation that public housing tenants find themselves in, as they are governed by a different set of rules when it comes to evictions. I'm not going to pretend to be an expert. There are experts on that. I would recommend connecting with the Mass Union of Public Housing Tenants. On their website currently already exists a document they have put forth, which would be a Bill of Rights for public housing tenants. So I would definitely recommend that. I'm going to wrap up here. The things that I've mentioned here are in no way meant to be an exhaustive list. This is just a way to frame the conversation around renters' rights and to begin that conversation, a conversation I look forward to continue to have. So I thank you for allowing me to testify, and of course, welcome any questions that you have.
Thank you so much, Mr. Martinez. Mr. Ponte Capelan, you have the floor.
Hello, thank you for having me, and thank you for sponsoring this hearing order. It's great to be back in City Hall as a former staffer. And as a housing rights organizer for about 5 years with City Life, I've seen the worst actors in this space. I'm talking about some landlords that have done some very atrocious things, like locking their tenants out, changing the locks on folks, like suing people for wanting to engage in collective bargaining. So I just want to, first of all, ditto on everything my friend here said. There's a lot of things that have already been talked about tenant right of first refusal, tenant access to legal support, which are all great. And there's already a lot of things that the city is doing, like the raft, for example. But the main issue is the average tenant doesn't know about it. So how can we create this tenant bill of rights and get it to folks in the easiest way so that folks know what their rights are? And I think something that the city has done already during the COVID emergency was they required landlords to send a notice to quit, not only to the tenant, but to the city. And then the city was able to send out an information packet to that tenant that was facing eviction. And that is a great practice because it allowed the city to, one, know where evictions are happening, because previous to that, the only way the city can know where eviction was happening was by going through the court. And we know as housing rights organizers and advocates that a lot of evictions never make it to court because folks just leave when they're told to leave, because they don't know that they can actually go to court and fight an eviction. So I think continuing that practice would be a great step, and it would be a way that we can deliver this tenant bill of rights in cases of displacement. The main things that I want to see in a bill of rights are protection for collective bargaining, which was mentioned a lot, a standardized lease. I've seen some wild things in leases, like the worst thing I've seen in a lease actually is a holdover clause, which basically says that at the end of your lease, if you don't leave when we want you to leave, then you're automatically going to be responsible for this giant fee. And then landlords are able to use that fee to scare them out. And that effectively is getting rid of a tenant's right to bargain, to collectively bargain, because then they're then hit with a lawsuit for thousands of dollars. And I've seen this multiple times. A tenant wishing to negotiate with their landlord on a rent increase or something like that, and instead the landlord sues them. So there's some horrible practices going on, and that's why we need a tenant bill of rights, because there are these bad actors in the housing and real estate industry. And it's, we're not talking about mom and pops landlords here. We're talking about corporate landlords that have made millions upon millions off of displacing black and brown folks. So we need to find solutions to stop these bad actors. So I think we can embed certain things into a Bill of Rights, like a tenant first refusal that was mentioned, like protecting collective bargaining. I have tons of thoughts to add to this, but a lot of it was previously mentioned for points. I'm just trying to get to how can we actually implement this and how can we deliver it to folks. So I think continuing that practice that the city did during COVID emergency is a great way of getting information out to folks and tracking evictions.
Thank you so much, Mr. Ponte Capellan. Mary Statos, am I pronouncing that correctly?
Stathos, but that's okay.
Stathos, perfect.
It's okay.
Stathos. You have the floor, Ms. Stathos.
Okay. So I want to first thank you for inviting me to speak. For everyone, I am a tenant organizer with the Greater Boston Tenants Union. I've been a lifelong resident of the Boston area and a tenant in Boston since 2016 and a tenant organizer since 2020. I really do wish that I could say that I became a tenant organizer out of the goodness of my heart, but I really became a tenant organizer out of necessity for my own health and safety. So in 2020, after 4 months of trying to get my management company, which at the time was Alpha Management, to fix some basic maintenance issues in my apartment, and then some larger maintenance issues in my apartment, particularly a hole in my floor where I could actually see outside through the subfloor. I tried to work with the city. This was in Medford, but similar tenant protections to here. I tried to work with the Attorney General's office, and no one engaged with me. There was nothing that anybody could do. No one knew what to do. No one could get my landlord to respond. Eventually, I started talking to my neighbors, and I got support through the Greater Boston Tenants Union, and I talked to all of my neighbors, and it was the same story: broken appliances, mold, pests, rats, cockroaches, like stuff oozing out of our walls. And we started to organize. We wrote a demand letter asking for better living conditions. We passed out flyers with reports of Alpha's previous history. If people are not familiar, Alpha has a very notorious history in the city, particularly Allston Brighton. And through months of organizing, we started to notice small changes. The trash that was piled up, barricading our fire exits, was removed. The hole in the basement floor was fixed. An entire apartment was renovated. And then we spread it into Allston, and that's where Alpha owns the majority of their buildings, and we started to hear stories. We were compelled to take a firmer stance against Alpha and to exercise our rights as tenants. And then on April 17th of 2021, I was given a cease and desist letter to immediately stop all organizing. They had gotten copies of all of the materials that we had used to organize and were threatening to sue me specifically. And they were saying that if I didn't publicly retract all of the statements I had made, that they would take myself and also the union, which they couldn't actually do. So it was just me to court. So I was singled out and scapegoated for the negligence of my own landlord. I called the Attorney General's office, I called the city, I called state reps, I called Greater Boston Legal Services. Everyone said that they couldn't help me because this wasn't a basic eviction, and it was really very basic landlord retaliation, that they would not get involved. I had to pay thousands of dollars for a lawyer myself. Luckily, the Greater Boston Tenants Union helped me fundraise, and we got all of those lawyer fees covered. And Alpha dropped the lawsuit, but they also dropped me. They stopped answering my calls. They closed my online portal so I could no longer pay my rent, and fully ignored me and forced me out of the apartment. So earlier in the meeting, someone had talked about, let me find exactly where I am. Someone had talked about wanting tenants to really stay in their apartment and get that lawyer and not make the decision to self-evict. I'm a person, I have a job, I have pets. I couldn't stand to be in a position where I was facing eviction, and I had to leave my apartment because I could no longer afford to continue with lawyer fees. And the lawyer that I had let me know that with the current tenant protections, under the Fair Housing Act, the landlord actually has to file something and do something. They can't just ignore you out of your apartment. And so I was ignored out of my apartment instead of being evicted because I didn't want to stay in my apartment past my lease terms to be a tenant at Sufferance. And this situation is not unique to me. Tenants who speak up about the conditions in their building are just silently pushed out along to other landlords. So without stronger legislation detailing what constitutes retaliation, tenants who speak up for better living conditions will continue to be displaced. And without stronger protections for follow-up by ISD on reported code violations, low-income and minority groups will continue to be disproportionately impacted by evictions and code violations. Your income should not dictate the safety of your home, and there should be material consequences for the landlords who choose to profit off of unsafe living conditions. I think this brings up the need for right to counsel. So statewide, 92% of tenants are unrepresented in eviction actions, and those are just the ones that make it to court and not the people who are forced out because they can't even afford a lawyer to get an eviction on the books in the first place and just choose to leave. With the end of the eviction moratorium, these protections become even more important. Michelle Wu's rent control proposal would end no-fault evictions, and that's ultimately not enough. The large majority of evictions are filed for non-payment of rent. Well, as a reform to halt the displacement
associated with the rising rents of Boston on its own, like it's a non-starter. It's not doing enough. We need to protect the tenants who are here, who work here, who live here, and who are part of this community. And I am a supporter of a tenant's bill of rights, but I'm hesitant to support due to the track record that landlords have to take any steps necessary to protect their own capital. This is small landlords, this is medium-sized landlords, this is the mega corporations. Housing is commodified. It is a for-profit industry, and tenants do not have the same luxury. Until we have a right to counsel, penalties for landlord retaliation, and having these steps in place for housing court to directly block evictions that are retaliatory, we're going to continue to see landlords exercise their power over the working class and continue to operate and commodify housing as a for-profit business. With the Greater Boston Tenants Union, we're in our own communities, connecting as tenants across landlords, across neighborhoods, knocking on doors, providing people with their rights, providing people with information about their evictions, how to fight it, and how to connect with legal aid. We'll continue to push for building tenant power and the decommodification of housing and for these protections, but ultimately, the work is on the city. Someone needs to step in. When we're organizing and we're being pushed out of the homes that we're organizing in to keep ourselves safe, someone else needs to step in to protect us. Housing is a human right. Thank you.
Thank you so much, Ms. Tasos. I am going to turn the floor over to Councillor Braden for questions for the panel, and then I will ask my questions.
Thank you. Thank you all for your testimony. Obviously, something really does need to be done. One particular, I don't know if you can shed some light on the issue around family housing, because in Alston, Brighton, so much of our housing, our family homes are rented to younger single folks. They need housing too, but I think one particular concern I have is in relation to across the city, we're seeing a decline in the number of families. We're seeing our population of school students falling, and we're not actually being very proactive in protecting the housing rights of families, because if it's a choice between getting $4,500 or $5,000 from a group of single individuals for your unit that's a family size unit, and a family who can't afford that, I'm just wondering, are you doing anything in that space as well? Because I think for me it's critical in they're protected, families are a protected class, but I really don't think that there's the de-letting issue, and there's the actual they're being priced out, so you never ever get to a challenge on discriminating against a family because the family can't afford the price. So I'm just curious about that in the context of the range of people that we're trying to provide safe and affordable housing for in the city.
Yeah, so on that, I would say a couple of things. I think one, we not being necessarily the city of Boston, we make it really hard to prove and be successful in discrimination claims in court, right? That's the first thing, right? We know families are protected class, but we know, right, like landlords are smart enough that, right, they're not putting no kids in their ads anymore, right? They're coming, they're seeing you have kids, and all of a sudden you don't get a phone call back. And so it does become a really hard thing to prove. I think another thing is when we're thinking about development in the city and things are developing and developing apartments, right? Like developing apartments that are designed for families, right? You can't just keep on having these developments that are just 2 and 3 bedrooms, right? Those might work for some families and for some smaller families, but it doesn't work for a 2-parent household with 3 kids or 4 or 5 kids, which is what we know is happening. And then, you know, like you said, we have students living in housing that is designed for families, which is fine. You know, I think to a certain extent, you know, when I was 22 years old and lived in the city, I wanted roommates. That was great.
We were all there.
Yeah, right. One, I needed roommates because I couldn't afford not to. And 2, I was new to the city. Roommates sounded really cool. That was really great. Right now I'm 30 years old. I'm lucky enough now that I live alone, which is what I want to be doing, what I think most of my peers my age would want to. But it's not an affordable thing, and so we aren't developing housing that's affordable to any of those people, right? We're not developing affordable housing for individuals that want to live alone, whether it be in a one-bedroom or a studio. We're not developing housing, one, that is simply big enough for families, never mind affordable to families. And so what the city can do, I mean, it's a really tricky thing, right? Like, the discrimination stuff obviously comes largely from the federal government and the Fair Housing Act, but it becomes a really challenging thing to do. I think part of what we need to do is educating people on the rights. I think a lot of parents with children don't realize that it is illegal to discriminate against them, and so I think a lot of times they'll self-select themselves out of apartments because like, well, I know I have kids, and nobody wants to rent to somebody with a bunch of kids. And so a large part of this is education, but a large part of it is honestly beyond the city. It's advocacy at the federal level to really step up the Fair Housing Act when it comes to protected classes.
Thank you. Thank you. And thank you for your work.
I wanted to thank you for that question too. In my experience at City Life, the vast majority of my cases were families, and particularly they were single mothers with children. So it's a huge issue, and I think what you mentioned around landlords trying to maximize their profits by renting out rooms rather than to families explains why, it's a possible explanation to why, as a housing rights organizer, we saw that it was mostly families that were dealing with displacement. So that's why a tenant bill of rights would be so helpful, because it would get information out to these families. And I just feel bad for the families that never got to City Life, never reached our doors, because we were able to give them the assistance they needed, point them to legal. So I feel bad for those families that never reached us, that never even knew that these resources were available to them. And something that came to me as my friend here was mentioning development. Folks, a lot of people don't know that development is discussed at the neighborhood level, in neighborhood councils and groups like that. Developers come to a neighborhood, they propose their proposals, and the neighbors talk about it. A lot of times, the folks that are given voice in these meetings are the abutters to a property, which are usually landlords or homeowners already. So I think we need to think of a way that we can uplift the voice of tenants in these spaces and give more teeth to these neighborhood councils so that they can tell a developer no unless you give more, unless you build more family units. So I don't know how we can build that into the tenant bill of rights, but I do see that as an issue and a way that we can increase more development for families is to increase more participation in the neighborhood level when it comes to development.
Thank you.
I do also just want to add to this, like, there is not a housing crisis. There is not a lack of housing crisis when we talk about developments. The issue of the Tenants Bill of Rights, this is a landlord issue. And this is about like fair housing and accessibility to the housing that does exist. There is enough housing for people. You're just not allowed to use it. Like, families are not being allowed to use housing that exists because it is commodified and privatized by landlords who want to profit the most off of it, and they're going to do that by renting to students and renting to young people who can afford, or not afford rather, their own housing and want roommates. That's not the fault of the students. That's not a fault of the young people without children. That is a fault of the lack of legislation around tenant protections and family protections. Like you guys had said, this is a protected class. We're not doing anything to protect them. When I was living in a larger building, it was all one bedroom or studio units. It was mostly families. Yeah. It was mostly families.
Yeah.
I was one of the only single people living in the apartments. The people next door to me, they had 3 children in a 1-bedroom apartment that was identical to mine, that I did not feel like I had enough room in for my own space.
I do really want to stress that this is not about building new housing that is $3,000 for a studio that none of us can afford. We need to put the pressure on landlords.
Yeah. Thank you. Madam Chair, I think it's my turn.
Thank you, Councilor Braden. So thank you all for sharing your testimony. A couple of things. There are rights that are afforded to tenants by the state. Do you see that the City of Boston exercising all of its own power to implement, to further bolster, I should say, the rights of tenants here in the City of Boston and the power that's afforded to us through our ordinances?
It's a tough question. Right, as we all know, right, we exist in the regime of home rule, and right, so there's a lot of stuff that like the city can't just unilaterally do, which is unfortunate, right, in that cities can't do what is right for them to protect their own tenants. I mean, I think a couple of other things, right, that cities have done, right, it's, right, the city could put money towards access to counsel, right? I don't expect the city to completely fund a right to counsel program in the city of Boston, but there can absolutely be increased funding so that people have these, right? Because I think ultimately what it comes down to for me is we can have all of the rights in the world. If you don't know what they are and know how to assert them, it's a problem. Or if your landlord has the power and leverage over you, you know, it is not a secret. I had a pretty well publicized loss of housing last year, right? And my landlord ultimately did some things that I probably could have gone to court and defended against. And keep in mind, I'm an attorney. I'm far better suited than most people to do that. But what I also knew for a fact was that I could do this, but the second that I go to court to do that, I have an eviction on my record. And that is there forever. And there's just nothing that we can do about that. And so even someone, right, a housing attorney, best positioned, knows my rights better than most people, knows how to assert them better than most people, right? There is still this inherent power imbalance. That happens. You know, another example being I had a friend a few weeks ago text me that, you know, they needed to move into a new apartment, their lease was ending, needed to move into a new one, and the landlord was charging an application fee, and he was like, isn't this illegal? And I said, yes, and he says, but I need housing. So what do I do, right? So yeah, he could have asserted his rights and said, no, you can't do this, this is illegal, I'm not gonna pay this. He even probably could have gone to court, got some damages, but in the meantime, he wouldn't have housing. And so I think, right, the unfortunate truth is the city has to go through the state to do a lot of things. The thing that the city can do is make people aware of the rights that they currently have, is make those rights accessible, is empower tenants to organize, as we've heard about, assert their own rights, and level that playing field and let landlords know that if you are going to take advantage of tenants, the city is going to come down on the side of the tenant, right? Which has not been the case. That is not the way that people feel. That is not the way that the city, the state, or any other body has done, the courts. And so I think it's imperative that tenants know that the city is on their side. It's even more imperative that landlords know, right? Landlords do what they will continue to do what they know they can get away with. They do illegal things every single day because they know no one's going to hold them accountable. And so the city, you know, really needs to step up on that front, enforce the rights that are there, make people know what their rights are, and make sure that that tenants are able to actually assert those rights.
Yeah, and it seems like also like a very clear and well-funded and supported reporting mechanism, because I feel like if someone knows that they're not allowed to be charged application fees, they should be able to see the application fee and call a phone number and say, this person at this thing, here's the link to this apartment, I am being, you know, they're violating my rights as a tenant, or they're charging more. And then the city should be able to take action, whether it be contacting them, you know, you can't charge. There should be immediate recourse for that, right? In the sense that even if your friend, for example, was going to pay the application fee because they needed to just like move forward immediately, that something on our end would also happen. That they would get a notice from the city saying you are in violation of X, Y, and Z, Mass General Law. These are the kind of fees that you can charge, and application fee is not one of them. And we don't really have that in place.
Well, right, like landlords respond to one thing and it's their pockets.
Yeah.
Right, at the end of the day. And right, when we think about, this is now I'm just brainstorming, I'm throwing out ideas in real time. Right, Mary? Yeah. Sorry, Mary, right, so talked about, right, the retaliation that she got for organizing. Right, one of the things that Mass actually does have, one of the laws that I think is really good, right? We've got really strong anti-retaliation laws, right? There's a presumption in law that if your landlord takes any type of detrimental act towards you within 6 months of you doing any host of things, reporting things to ISD, organizing, right, you're entitled to 3 months of rent as damages, and lawyers' fees and more. Right, so what would it look like if, when Mary went through what she went through, instead of having to call a bunch of lawyers, she went to the city, and the city had resources. Maybe if it's not lawyers, but the city saying, here is your form complaint, here's the thing, we're gonna help you pre-fill this out, go to the court, file this, scare your landlord because, right, the law is clear, right? There are things that the city could be doing to make sure that people are available, right, can avail themselves of currently existing rights that just don't happen because
Also
people
just
are afraid.
Technology.
Yes.
Like you should be, like you said, like there's like, these are all of your rights. Here are the ways that you file complaints for all of them. Fill out this information and here is a printed out version with all of the information that you have to print it out, bring it here.
Absolutely. I mean, right, for me, right, in my work as a housing attorney, as someone that is in court, that is the biggest thing, right? There's knowing your rights, but I think the thing that doesn't get talked about a lot is how do you actually assert those rights in a court of law, right? You have you do, right? Yeah. Obviously, the point here is we need a lot more rights in Massachusetts, but the fact of the matter is there are still some solid rights in Massachusetts, but one of the things that people don't know is, right, there's a timeline, right? You have to assert those defenses before you ever make it into court. So I can't tell you how many times, right, I'm normally in court on Thursdays. I can't tell you how many times someone has come up to me in court and said, here are the pictures of the roaches in my apartment, the rats, the mold, the ceiling tiles falling off. This is my defense. This is why I haven't paid rent. I know my rights. I'm going to win. And then I say, this is great. I'm so happy you have this. Did you file an answer, right, which is a legal document? Did you file this answer 3 days before your first court appearance, and did you give a copy to your landlord? And they say no, because why would they do that? No one knows that that's what you have to do. And depending on the judge that you're in front of that day, some judges might say, okay, fine, I'll still let this in, but it is well within the rights of a judge to say no. And we've seen it happen. It doesn't mean you have all of this proof, your apartment is falling apart, but you didn't follow this very specific, opaque legal process. So now, I don't know what to tell you, you're gonna be evicted. And right, there are things that this, right, like access to counsel, right? Just having a lawyer through that process is really great, but there's also plenty of things that the city can do to prepare tenants to do those things on their own if they need to. Obviously, the preference is they don't do that on their own, but a well-prepared tenant makes a world of difference.
Yeah, and thank you for giving that answer. And I think one of the things that's coming up for me in that sense is also, I've been thinking about tenants' rights and renters' bill of rights during this conversation as the rights that you have as you're looking for housing, your rights as you're negotiating your housing, your rights once you are living and a tenant inside the housing, and then your rights after you either close out your lease or decide not to renew your lease and move out, right? Because there is also, people have the right to receive their security deposit back, right? And the things that they can charge you for are very clear, and the timeline by which you have to receive it back is very clear, and that very seldom happens.
Absolutely.
And so, like, what is the recourse in that sense? And I'm saying that from personal experience because right now I'm waiting for my security deposit. So, and it's been 2 months, and they have 30 days.
I was going to sounds like treble damages.
well, this is what I mean, right?
Yeah.
Like, again, I'm an elected official. You better believe that at the 60-day mark, I sent an email saying you are in violation of this law. You have 30 days. I need you to send me an email when this is in the mail now.
Yep.
Right? Like, so, but a lot of people don't know, not only that they have that right, but what action to take after that. And obviously that is not like the appropriate legal action, but like you said, scare them. They're like, oh no, this person is going to bring us to court. Yeah.
I do just want to add, and I think that I had wanted to add this earlier, but then you had said this as well. I think this is what you're saying just now is really important that these things exist. Like, this right already exists and you know it, to get your security deposit back, and you are attempting to exercise it unsuccessfully because landlords do not care.
Yes.
So with a tenant's bill of rights, there almost needs to be a landlord's bill of consequences. Like, what happens? That was good. I'm proud of me for that.
A landlord's bill of consequences. I love that. Actually. Yeah.
But it's real. So, like, my landlord violated my rights, but it wasn't within the, like, specific documentation that it should have been, but I was forced out of my apartment. They closed my account. I had all of the proof of this, and I got a lawyer. I paid a lot of money for this guy. He called himself a movement lawyer, and he was largely helpful. But he said, you know what? I'm sorry. There's nothing we can do. I called the city. They said, I have no idea what to do. I called everyone that I knew. No one could do anything, and I had to move, and I had to pay $7,000 to move in the middle of the pandemic. And it's crazy that this expectation is there, that, like, even you as a city councilor are saying that my landlord has more power over me. This is a power dynamic issue. And, like, tenants have power when we work collaboratively, when we organize together. Like, we need to have collective organizing and the protections against organizing, because the landlords have organized, and they have organized with the state, they have organized with the federal government. They own the land, and they get to decide. They call the shots. And, like, more has to be done to hold them accountable.
Yes.
Yes, and on that theme of enforcement, it was mentioned earlier by Director Terrell, having some sort of legal avenue to if landlords violate the Bill of Rights. There's a legal recourse you can take in housing court. But I also think the city can do more to stop these bad actors from continuing business as usual. Landlords that are displacing folks left and right, giving folks giant lawsuits, they should not be able to continue to develop as easily as they do. So I think, I'm forgetting exactly what it's called, but there's been places that...
I know you're talking about the anti-discrimination, well, the scofflaw, but you're talking about the certificate of non-discrimination.
Exactly. So basically, when a landlord wants to develop in a new area, they have to go to the neighborhood council and show their proposals. If that landlord has a track record of being a displacer, there's an avenue for tenants and people that have had these experiences to come and say, no, this landlord did X, Y, Z. I don't think they should be allowed to get these variances for this proposal that they have, to really affect them where it hurts, like we mentioned already, in their pockets. So unless we think about solutions in that way and enforcement in that way, they're just going to continue to not care.
So I have one last question, and then we're going to go to closing statements before we do public testimony. What do you think is the the challenge, the biggest challenge or the biggest hurdle to jump through to organizing tenants? So when we have organizations that are incredibly skilled at it, you know exactly what to do, like, what are the hurdles to making sure that every public housing development in BHA has a tenants union, to making sure that every JPNDC building, Urban Edge building, right? Like, what are the hurdles to ensuring that, what is stopping us from making sure that tenants unions are proliferating everywhere across the city?
People are scared, terrified.
Okay.
They're afraid of retaliation. I've been to so many buildings knocking on doors and trying to start tenants associations. And there'll be times where it'll be a building that hasn't been sold yet. And we as organizers can see, like, this building looks like a good purchase opportunity. Let's canvass it preemptively in case someone buys it. So we'll canvass it. We'll come back for 3 weeks, and everyone will be scared to talk to us. It's not until a new landlord buys it and gives everyone eviction notices that then people are more willing to speak to us, because they're in imminent danger of being
it's
displaced.
harder to preemptively have the infrastructure to have people advocating for themselves on an ongoing basis without, like, an outside force that kind of, like, sparks it.
Yeah, and even with the outside force, like, we'd have to have that consistent dialogue with folks and let them know, like, these are your rights. Don't be afraid, because if they do retaliate, this is what we can do. You can get triple damages for retaliation. In any, if you guys organize, for 6 months you guys are protected. Like, these rights exist that folks don't know, and even when they have an organizer in front of them telling them that everything's going to be okay, I got you, they're still afraid because of retaliation of land. So we really need to crack down on landlords that do this type of retaliation.
Thank you, Alice. Mark, and then Mary.
I will say, as someone who has organized in both my own building and helped organize in a number of other buildings across the city of Boston, I would say fear is obviously a large part of it. But I think the biggest part, though, there are multiple buildings that the GBTU has successfully organized throughout the city. And the number one thing is getting landlords to the table for negotiations. We have buildings that are 100% organized, and the tenants are ready to go, and the tenants want to make these changes. There's zero incentive at all for landlords to come to the table to negotiate that, because it only costs them money. Because the only issues that tenants have are issues with their housing, and like that's going to cost the landlord money. So without any of that, then they have no incentive, and then it's not happening. And then ultimately, the biggest thing too is like the lack of rent control, and then the turnover of housing due to that is that people cannot afford to live in their apartments. So they eventually have to move, and why are they going to stay in that apartment with?
Yeah, so you end up having, so there is.
Every 2 years is a different set of tenants.
Yeah, exactly. The issue, starting organizing all over again, yeah. So you have the issue with starting unions, and then once you have a union, the landlord is not coming to collectively bargain to the table.
Yeah, and I think the only thing that I would add to that is resources for organizers, right? Expecting that these organizers are continuously tenants doing it on their own time on top of the lives that they're already trying to live while trying to fight for their own housing is a really massive burden to put on people. And so I think resourcing for these organizations that are doing this organizing, paying organizers, giving people the resources to really run the type of robust organizing campaigns that these type of things take. And then, I just want to echo the idea of fear, right? It's the same whether it's tenant, labor organizing, right? Any type of organizing, right? The big impediment here is fear. And in thinking of, we're at City Hall, talking with City Council about what this looks like is, what would it look like if while we are resourcing organizers, while they're going around knocking door to door, right? You've got an organizer and someone's from the Mayor's Office of Housing Stability saying, hi, I work for the city. These are your rights. These are the things that we're going to stand up for you and with you, right? Because like Mary just said, right, like it's pressure. Like what gets people to the table is pressure. And so if you just have a bunch of people organizing and that landlord just knows that, well, come September 1st, half of these people are going to be out of here anyways, they don't have a whole lot of incentive. But if the mayor or a city councilor, the city council as a whole, right, is standing with that tenants union, standing with those organizers saying, no, as a city, we're watching you. We're expecting you to come to this table because like was said over here, right? Like eventually those landlords are coming back to the city for their right. They're coming for a permit to develop. They want to buy something new. They want to refurbish their apartment, right? Like they constantly need things from the city. Right, and so what does it look like for the city to flex that muscle and say, all right, you're coming to ask us for a thing? Well, here are all the things that we've expected you to do that you've not done, so no. We're not going to do that, right? So the city has the big stick here, right? The city, right, has the carrot, the stick, whatever, whatever else that analogy is, that could be used on behalf of tenants. That just simply hasn't been, right? And that is where, right, if we're talking about what this ultimately comes down to is a power imbalance, right? Like we need the city to come down more than just like rights on a piece of paper, but like in a real way, right? Like using the bully pulpit that the city has to put, some weight back down on the tenant side when we're talking about that imbalance.
Thank you so much. I'm going to go to Councilor Braden for any closing remarks, and then we are going to go to public testimony. We have someone on Zoom, Ian from the Greater Boston Tenants Union. Please be ready, and Michael Kane, who is here with us in person.
There's Michael up in the back there.
Yep. Councilor Braden, you have
I want to thank you all for your great work. The work that you do is so important. Some good news in the sense that we talked about what the consequences for landlords that are abusive and aren't doing the right thing. I filed an ordinance, a scofflaw ordinance, a couple of weeks ago that would have consequences, because we had a hearing. Councillor Edwards and I had a hearing 2 years ago now, with all the changes in the city. We're sort of catching up to it again. But it's a scofflaw ordinance that when a landlord is persistently a bad landlord, and that there's going to be consequences, so that when they do come along and want variances or they want to build a new building, or that there's some teeth that will hopefully have them pay attention and do the right thing more often than not the other way around. So, that'll be, I'm sure we'll be inviting you folks back to be part of that conversation as well. But, I really want to thank you for the great work. And I think as we all work together on developing a tenant's Bill of Rights, I think we've had lots of good input today. And, I'm hopeful. I'm hopeful that we're moving forward in the right direction and that we'll get there at the end of the day. And so thank you all. Thank you, Madam Chair.
Councillor Braden. Thank you all. I just want to echo my gratitude to you and the panelists from the administration as well that were here with us before. You have done an incredible amount of work and have really taken time, not just in your professional lives, but in your personal lives, to make sure that your neighbors can stay in their homes. And I think, Mr. Martinez, like you said, there is a power imbalance, and the city should be on the side of the tenant. We should be balancing those scales. And my hope is that with the Renters' Bill of Rights and with all of the other renter protection work that will hopefully come through this committee, we are really putting our finger on the scale to be on the side of the tenant. So I'm really grateful and looking forward to continuing this conversation. My hope is that we bring this conversation to our neighborhoods and partner with community-based organizations that do housing justice work, with tenant unions, to really convene renters to tell us what they would like to see in the Renters' Bill of Rights. My hope is that process will take anywhere from the next 3 to 4 months, and that we can present something that includes city ordinances and also state-level work that we can do to increase renter protections by the early fall, so that the council can work on it before this year is up. So if any of you are interested in being a part of that work, please make sure to stay in touch with our office, and we would more than likely love to have you. So panelists, you are excused. We're going to move on to public testimony. Michael Kane, please join us here for public testimony. Please introduce yourself and your affiliation for the record, and you have 2 minutes for testimony. Next up will be Ian from the Greater Boston Tenants Union on Zoom, so please be ready.
Me here?
Right here.
Right here. Okay, thank you.
Yep.
Thank you for holding this hearing and for waiting patiently this long.
Thank you.
For the record, I'm Michael Kane. I live in Jamaica Plain. I'm the director of the Mass Alliance of HUD Tenants. We're a tenant union in privately owned, government-subsidized housing, including mass housing buildings like the Forbes in your district, and several buildings in Brighton that we've worked in over the years. So we started organizing in '83 in HUD multifamily housing, vulnerable, lower-income people, mixed racial background, a lot of elderly families with children, so particularly vulnerable people. All the landlords are large corporate landlords, and a lot of them were starting to convert their buildings to market rate, and we were fighting that, or they were in very substandard condition and actually going through HUD foreclosure, so there was a risk around that. We started organizing one building at a time. We very quickly realized the fear factor that is so deeply rooted. Everybody is afraid of doing anything because they'll be evicted. And that's true today, despite the rights that we were able to get established in HUD housing. So in the 80s, we drew up a list of things that were common techniques that landlords use, like evicting, threatening to evict, buying people off, sexual harassment, all kinds of techniques to dominate and control tenants and prevent them from organizing. So it took 10 years, but later we founded the National Alliance of HUD Tenants because we realized we couldn't get very far with HUD just locally. So we reached out to sister organizations around the country, came together in the early 90s, and we worked several years. We finally got HUD to adopt a right to organize regulation, which I have copies here. And it is considered pretty much the gold standard for the right to organize, but it's only in HUD multifamily housing. It only applies to HUD multifamily, and not all of that. HUD, in its wisdom, says that project-based vouchers run through the Housing Authority aren't covered by the right to organize. Low-income housing tax credit units are not covered. So there is currently an effort at the national level to extend those rights to other federally assisted categories of housing. And we worked with Congressman Levin's office last fall to file the Right to Organize Act at the federal level. It hasn't been refiled in this session. We're asking Rashida Tlaib to do that in the House, and people are talking to Fetterman in the Senate. But it's going to take years to get those. But what we learned from that is there is a way to codify the right to organize. There is a way to do it. There is a way to list protected activities, which is what these regulations do very well. You have the right to leaflet, door knock, post flyers, for example. Very specific things. It also, there's a list, there's another document, not the regulations, but there's a HUD handbook that listed typical ways that landlords harass people and prohibits those activities. So that list and the list of protected activities could be reflected in a city ordinance. And I mainly wanted to come today to talk about the right to organize dimension. We had great testimony from everyone else about, the obvious state legislation that's needed, a bunch of things, just cause and so on. But the city, what you can do, I think, is fund the Office of Housing Stability. Give them the resources. And I am not sure, I think you can fund the right to counsel out of the city budget. I don't see a prohibition on that as a state law thing. There are other cities that have done that.
Yes, we can.
So I think that is something that you all can do in the budget coming up, talk to the mayor, get it in there, and then give the resources to the OHS to do the education things and perhaps the tenant organizing things that people have talked about. So at the federal level, HUD requires every landlord to, this is something we got them to do, we wrote the brochure, distribute a brochure to every tenant each year upon lease signing. So that is now done. They've done millions of these brochures in 20 languages, Braille. So that's a requirement at the federal level. There's no reason that can't be added to a city ordinance, run it through the Office of Housing Stability.
Thank you so much, Mr. Kane.
I want to offer my assistance to the committee, to OHS in coming up with the right to organize pieces of this. The last thing, the city of San Francisco has adopted, used the federal regs that I just talked about to adopt a right to organize for private tenants. Yep. And we can get that ordinance and share it with you as well.
Thank you so much, Mr. Kane. I really appreciate it, and I'll have my staff follow up with you about the HUD right to organize information. Next up, we have Ian from the Greater Boston Tenants Union. Ian, please introduce yourself and your affiliation for the record, and you have 2 minutes. We can't hear Ian in the chambers. If we can put the volume up here. Give us a second, Ian. We're going to adjust so we can hear you. Yeah. We still can't hear you, Ian. Do you mind checking to see if it's on? Yeah, his mic is on. Do you mind checking if it's on your side? Mic is on, Sandy. Ian, can you try talking to us again? Okay. Ian, we're going to try one thing, asking if you could leave the meeting and then come back to see if we can pick up your sound very quickly. Thank you.
Remote participation is wonderful. It works. We just got an extension to 2025. Did you see that?
I did see that, yeah, which is good. 2 years. Okay. Thank you to the folks who are watching at home and everybody who's here with us in the chambers for being so patient. We are committed to making sure that our meetings are accessible, so we are accepting virtual testimony, and sometimes technology is not our friend. It looks like we have Ian back. Let's see. Can we hear you now? Okay. It looks like we still cannot hear you, Ian. So what I'm going to ask you to do is I'm going to thank you for braving this hearing. And if you could submit your testimony in writing to the committee so that we can send it to all the counselors and accept it for the record, would you be willing to do that? Thank you so much. And I'm sorry that we couldn't figure out the Zoom today, but I look forward to reading your testimony and passing it on to my council colleagues. Thank you so much to everybody who is here with us. That concludes our public testimony period, and this hearing of the Committee of Housing and Community Development is adjourned. Thank you.
Very good. Thank you, Madam Chair. Thank you. Good hearing.